Number two, madam. Two. Yes, madam.
What do you want?
Maybe list after 3 weeks, madam.
After 3 weeks?
Yes, madam.
Who is for the other side?
Other side is for the Pangin sir is there. I have taken the consent from
Okay. You're Mr.
Dia, madam.
Planning Council for you're for appellant.
Yes, madam.
Appellant.
No, I'm for the respondent.
Respondent.
Yes, ma'am.
Okay. Planning Council for the respondent on the consent of the Planning Council for the appellant. Praise for listing this matter after
3 weeks, madam.
3 weeks. The prayer is allowed. List this matter after 3 weeks.
Much of
May I please, my lord?
Yes.
My lord, I beg to mention item number 31 and 33.
Yes.
I have taken the consent of Mr. D. Pankaj, my lord. I humbly pray, my lord, the matter will be listed for 4 weeks, my lord.
Okay. This is criminal appellant.
My lord.
Okay. Mr. Ojingpada, PP, on the consent of the other side, prays for listing this matter after 4 weeks.
My lord.
The prayer is allowed. List this matter after 4 weeks. 33 also.
Yes, my lord. 33 is a regular first appeal, my lord.
Oh, first appeal.
Yeah.
Okay. Here, Mr. Ojingpada, you are for respondent.
Yes, my lord.
Respondent number?
The sole respondent, my lord.
Sole respondent. Okay. Here you write respondent, sole respondent on the consent of the other side. Okay.
Obliged, my lord.
May, my lord.
Yeah.
I beg to mention one criminal petition, my lord. This may be taken on 3rd of this month.
Whether the mention can be made or mention is made before the senior bench.
Criminal petition
This is criminal. Okay. So when do you want?
on 3rd Wednesday, my lord.
Okay.
Much obliged.
Ma'am,
Yes.
I beg to mention item number 32.
32.
Yes, sir.
Okay.
I'm for the petitioner here.
Okay. What do you want?
PP's, we have took the consent of the PP or is out of session. In that case, matter may be listed after 2 weeks.
Okay. You are for the
Petitioner.
appellant.
Yes, sir.
Okay. Mr.
Bidulom.
Land Council for the appellant on the consent of the Land Council for the respondent. Prays for listing this matter after
2 weeks.
2 weeks. The prayer is allowed. List this matter after 2 weeks. Okay.
Obliged.
May I, your lordship? Your lordship, I beg to mention item number 22 and 23.
20,
22 and 23.
23.
We have taken consent already. So matter may be listed after 2 weeks.
This is for order only.
Yes, your lordship.
Okay. You are Mr.
E. Payang, on behalf of T. Tayang.
Okay. Mr. P. Pai, Land Council, sorry, appearing on behalf of Mr. P. Pai, Land Council for the appellant on the consent of the other side, prays for listing this matter after
2 weeks.
2 weeks. The prayer is allowed. List this matter after 2 weeks. Okay.
And your lordship, there is one more matter, item number 30. The
You have mentioned 22 and 23.
yeah, and there is one more item,
Okay.
item 30.
30.
30, yes, your lordship.
Yes.
The council is out of station.
Okay. Who's council?
For respondent.
Appellant, respondent.
Yeah, respondent, your lordship. Therefore, your lordship, the matter
Okay,
may
who
be
is
listed
for-
after 2
Who
weeks.
is for the appellant?
M. Kato, sir.
He is present.
Yeah.
Have you taken consent?
I have informed him. Yes.
What he says?
He says, "Karke dekh lo." Try it.
No objection.
No objection.
Okay. Mr.
E. Payang, your lordship.
Samit says the appearing, the arguing counsel, Mr. Sibukoya, is out of station and prays for listing this matter
After 2 weeks.
after 2 weeks. You are,
I am for the appellant, my lord.
you are for the appellant. No
Yes.
objection.
For that effect, yes,
Okay, Mr.
since he is out of station.
Okay. Appellant. Okay, Mr. Kato, Planning Council for appellant has no objection. He is also present and has no objection. Accordingly, the prayer is allowed. List this matter after
2 weeks.
2 weeks. Okay.
Much obliged.
My lordship,
Yes.
I'd like to mention item number 1. The leading counsel, Mr. T. Tagum, is out of station.
Okay.
The matter should be listed after 2 weeks, my lord.
Okay. No. Your miss.
Theory.
So what about the other side?
Uh,
Have you informed the other side?
I don't know, sir.
So
Uh,
item number 1 only,
yes,
let it go.
yes.
Okay. We'll adjourn, let it go. Okay.
Thank you, my lord.
Yes.
May it please your lordship. Your lordship, I beg to mention item number 34 here. I'm for the appellant, your lordship. I've taken consent.
Item
34, 34. I'm for the appellant now, appearing on behalf of conducting counsel T. Bagam. 34.
Okay, you are for the
After-
appellant.
Yes, your lordship, I'm for the appellant. I have taken consent from other side.
Okay.
It may be listed, and Kakum. After, it may be listed
Appearing on
after 2
behalf
weeks.
of Mr.
T.
T.
Bagam.
Bagang, Land Council for the appellant on the consent of the other side. Praise for
After 2 weeks. Your Lord.
listing this matter after 2 weeks. The prayer is allowed. List this matter after 2 weeks. Okay.
Highly obliged.
Yes.
My lord, may I?
Yeah.
My lord, item number 24, my lord. I'm here for the petitioner, my lord.
Yes.
I have to file my rejoinder, my lord. So 2 weeks may be given, my lord.
Okay. 2 weeks.
Yes,
So wait for the other side, whether they are present.
Yes, my lord, he is a Pasigat-based advocate here.
Okay. So he want to file rejoinder. Yes, sir. Okay. Mr. Binta Picha, Land Council for the petitioner. Praise for how much time?
2 weeks time.
2 weeks time, and pray, and is granted for filing. Rejoinder.
Rejoinder.
Okay, stop. Mr. Omodi, non-counsel for the respondent is also present. Okay, list this matter after.
2 weeks, my lord.
Okay.
Well, entry may be continued, my lord.
In the meantime, the interim or the past earlier shall continue.
Okay.
Okay.
Obliged, my lord.
Till the next date. Yes, she mentioned. Is prayed for by the Land Council for appellant, for appellant. List this matter after 2 weeks. Okay. Yes.
The accused person was arrested in SRC case number 3, 2023,
Case diary was called for.
Yes, madam.
on 21 January 2024. He was arrested.
Arrested.
Then thereafter, a bail petition was moved before the district session district special judge, and it was rejected on 13 February 2024. Then again thereafter, another subsequent petition was also filed, and that bail petition was rejected on 23 2000.
Subsequent bail application before the same court.
same court, মানে from certain subsequent development on the basis of that.
Okay.
Then after that, we have filed this. Now, while the bail petition was moved, that time, before the district and session judge, special judge, the health status of the accused person was also called forth in the court. Accordingly, the judicial magistrate, the medical officer who are look after the judicial custody, they have sent the report. Now, here in this case, my submission is only on two grounds. One is on health ground. Another is on parity. Now, let us come to the health ground. Now, I have filed additional petition, additional affidavit in my bail petition. Put it now. Page 9,
Page 9, additional affidavit.
additional affidavit,
Just a minute, no.
page 9.
It has no mark. Where is the additional affidavit? Additional affidavit? Have you received the additional affidavit?
Yes, my lord, I have received it
Okay.
yesterday.
It hasn't come yet.
Huh? No,
So it is not on record.
no. It was sent for calling the record. Huh? Then,
So, he was arrested on,
21 January,
what is the maximum of punishment? The,
Ma- maximum punishment is all the sections other than the 409, all are below 7 years.
Okay, and then 409 is?
There is misappropriation. Whereas here in the case, there is
the
no
punishment.
punishment is 10 years,
No, he was arrested on 21 January,
January.
February, March. It's been more than 60 days,
There, 2 months, 11 days.
11 days.
They are till today.
So what is the statutory period?
90 days, my lord.
90 here.
Yes, my lord.
90 days.
Why?
as
Because,
per-
my lord, there is 409, my lord, criminal breach of trust.
Okay, that is right.
Yes,
Okay.
only that section, my lord. Otherwise, like, my lord, it's
90 days is maximum punishment is? No, so 409 is
409, my lord, 10 years, my lord.
10 years,
10 years.
10 years.
Can you see 167 2?
My lord,
167 CRPC 2. What does it say? The maximum is 10 years.
yes, my lord.
Let us see.
May I read, my lord? The magistrate to whom an accused person is provided under this section may, whether he has or has no jurisdiction to try the case, from time to time authorize the detention of the accused person in such custody as such magistrate thinks fit for a term not exceeding 15 days
10 years.
in the whole, and if he has no jurisdiction to try the case or commit it for trial and consider further detention unnecessary, he may order the accused to be forwarded to a magistrate having such jurisdiction, provided that the magistrate may authorize the detention of an accused person otherwise than in custody of the police beyond the period of 15 days if he is satisfied that adequate grounds exist for doing so. But no magistrate shall authorize the detention of an accused person in custody under this paragraph for a period paragraph for a total period exceeding 90 days, where the investigation relates to an offense punishable with death, imprisonment of life, or imprisonment which is not less than 10 years.
This is not less than 10 years.
Not less than 10 years.
So It is not the, is it 409,
Yes, ma'am.
the punishment is not less than 10 years.
Imprisonment, if I go to the classification 409, ma'am.
Hmm.
Punishment,
Hmm.
imprisonment for life or imprisonment for 10 years.
Okay, 409.
409.
Okay.
10 years.
Otherwise, the rest are, my lord,
10
below 10
years.
years.
Now, another point that regarding the health. They have medically they have submitted the report, and as per the report, as per report, 2nd March 2024, 573 mg. Petition amendment. Petition amendment. 573 mg. 5/3/2024.
So where are we?
In the medical report, medical report.
Page?
I saw medical report. Medical report kadwa ta? Right na? This is the medical report.
What is this?
This is the medical report furnished by medical officer in charge, Health Center District Jail.
This document has not been annexed.
No, that document has been filed in the additional affidavit.
So this document was presented or annexed before the special judge at the time of.
No, at the time of hearing, this document was produced before the special judge by the jail authorities from medical officers.
And while disposing of the bail application, this document was also considered.
It was to be considered, but
It was also considered.
no, it was not considered.
The document was there. It was placed before the special judge.
Special judge.
Then it was considered only.
It was he was not taken in the serious. Now, what I mean to say is that as per the report. Now, yes, a blood sugar reading of 300 mg, dear, or more.
Where are we reading?
Second.
In the said report.
Huh?
In the said medical report.
No, this is a Michigan Medicine University of Michigan.
Have you annexed that document?
No, this document I have not annexed. But
why you are reading? Where from you are reading? It is not here.
No. I am describing the content of when the sugar.
Why this document has been presented here?
No, to compare with the report, medical report.
Which report?
Medical report furnished by the medical officer of the jail.
Okay.
Here,
whether you have annexed that document.
In additional
page
9. Nine.
Yes. So what I'm saying, my inquiry is whether this document, as you said that this document was presented before the special judge at the time of considering the bail application,
Yes,
at the time of disposing of.
yes.
So since this was considered, what is the new thing before this court? After considering all these only, your bail was rejected. What is the new development thereafter to be considered by this court?
There are two grounds. One ground is medical. And on the basis of this, though the trial court has not taken in this area, but when a person, the blood sugar is more than 300 or it becomes 300, it is an abnormal. This is not a normal. That normality and abnormality was not considered.
Present complaint, no specific complaint except for diabetes. These are the report.
Then
You want this document to be reconsidered by this court?
yes, one way, this is an emergency and you need go to the hospital right away. If you are not treated, you can go into a coma.
Where it is?
Now,
Where can we find?
in the second part, second pages of the Michigan University's report, medicine report.
Where? Page? Not annexed.
Not annexed. This is
Why should we base on the document which is not annexed?
not annexed, but this is only for this thing, knowledge.
No idea. You should have annexed. If you want to base on certain documents, you should have annexed for consideration. If you want dead points to be considered, you should have annexed.
That anyway, this is very serious, but it has the learned trial judge has not taken it as a serious. Now that is another aspect. Another aspect is the in this case, including the present accused, 5 persons were arrested.
They are in this case.
In this case, same section, same case, and
Same rank.
not same rank,
Okay.
but all of them have been granted bail.
Hmm.
Now, that order, in additional affidavit, page 10, Annex 2.
Yes, what is that?
Here, the Lomkan Rekun, who was also arrested on 9/2/2024 in connection with the SIT vigilance case number Iman, same case, under same section of the IPC. He was serving as UDC.
And yeah, you were?
I am DDHC.
Okay, I think
Na-
there is a
na-
difference.
Yes. Now again another is page 14. Page 14. When he was granted bail.
Okay, and his rank was, he was serving as
UDC.
UDC, but you are the
UDC.
boss. You were the boss. Yes.
And another is 14. But same section. Now another case number 27 of 2024. He was also arrested and he was granted bail on 21/3/2024, and he was also served as LDC cum cashier in the department. Now, another is bail application number 28/2024.
I
Sa-
think that is not comparable because
Satnam Tachai versus state of. Now, my main case, in the main petition also, here in the case, what is the allegation? Allegation is illegal appointment. Illegal appointment. I being a DDHC, this Deputy Director of School Education, I have no power at all to make any appointment.
okay.
Now, there are 78 illegal appointees. Out of 78, 4 was appointed by the Jani Laji, the then Director of School Education. Then, secondary education, he was appointed 4. Another illegal appointee, 74 now, was appointed by Tapugao. And Tapugao, though he has appointed all those illegal. And I being the subordinate officer, as a deputy director, I have accepted the appointees. I have allowed them to join in the service. That is the only thing. But all that there is no dispute about the signature and all the appointees. No one says that I received the appointment order from the Deputy Director of School Education. All of them says that they have received the appointment order from Tapigao. But Tapigao has been granted bail, anticipatory bail. And again, he has more anticipatory bail in this case. Today, this case has been listed here. Now, but he has been granted bail. SIC 2 of 2023, he has been granted bail. And anticipatory bail.
Same PS case, SIC case.
When the SIC has registered cases from district to district wise. Now 1, 2, 3, 4, 5, 6, 7, up to 7, they have registered the case on a district wise.
Okay.
So Tapigao has already managed bail in the other district.
What is this?
In that case, parity should be given. I am entitled for the getting of the bail for parity.
We'll have to see. We'll have to see the case diary.
And in the main case, Annexure 6, page 34, Tapigao was granted anticipatory bail in SIC case number 202 of 23.
So we are in which case, which PS case?
02.
02, same.
02 2023. My case is 03 2023.
Okay, 03.
03.
He has been granted bail in 02.
02. And that interim bail was regularized on
He was granted bail on what ground?
only on medical ground.
Okay.
Medical ground, they said that there was a heart operation. Only on that ground.
Okay.
Now, he regularized.
You have
Now,
what heart problem?
after that, again, a regular bail was granted. That is page 39, Annexure 7 of my main page.
Yes. So this is
Bail application 11 2024. Tapulgaon.
he was arrested prior to your arrest.
That is in that is in the 40 here he 4/04/2023. The same section, same allegation.
And he was, at the time, he was in which rank?
Director,
Director. And
director, director of elementary education.
Okay, and you were deputy director in a
I-
district.
I was the deputy director in the district,
Who issued, normally who issued the appointment order?
director. Director has the power. He has appointed all the illegal appointees, and the illegal appointees, they brought their appointment order and came to our office, and we accepted their joining report. We have accepted the joining report. That is the only thing. So total number is 78
So what is the allegation against you then? Illegal appointment.
illegal appointment. But why I have accepted? I am being the subordinate officer. I am bound to accept.
You have annexed the FIR also.
Yeah, in the FIR also I have an.
Let us see.
FIR is. FIR is page 18. 18 onward.
Yes.
Actually, this is a report which is submitted by the Deputy Commissioner of Thanglang to Chief Secretary. Then from Chief Secretary, again, it has been forwarded to the Under Secretary Vigilance. The Under Secretary Vigilance has forwarded it to the SIT, and SIT has stated that report as FIR. In the last it is report, in view of above, the report forwarding as the DC Thanglang had captioned it dated 4/7/2023, along with dossier is stated as FIR. As per this FIR, they never say that I have made an illegal appointment. They have found their appointees, illegal appointees. They have detected it. But they never say that it was appointed by the Deputy Superintendent of School Education, DDSC.
Yes, what the case hearing reveals.
Before going to the case study, Malod, can you come to the main petition, the FIR, Malod?
Main petition.
Yes, the FIR, the page starts from page 18, Malod.
Yes.
Malod, can you turn to page 20, Malod?
15, 20.
20, Malod.
Yes.
Malod will find, Malod, there are 78 illegal appointees, Malod.
70s,
In numbers.
78.
78.
78, yes.
Yes, Malod. And out of the 78, Malod, 5 TGTs, trained graduate teachers, 29 PRTs, primary teachers, 8 UDC, 13 LDC, and 22 MTS.
Hmm. Okay, this was issued in whose name? Who normally appoints?
No, it was issued by the then Director Elementary Education, madam. But
Okay.
as per the investigation, madam, it was revealed that it was issued in connivance with the DDSE, madam.
Okay,
And while preparing, the modus operandi was that, madam, they were appointed illegally, madam.
hmm.
And they were appointed, but then they did not join the service, madam.
They did not?
Join the service.
Okay, these appointees.
Yes, my lord.
Not yet.
Yeah, no, they joined, afterward they joined. They were appointed back in 1719, my lord. In the year 2017, some in 2017, some in 2019,
Okay.
but they joined in 2022, my lord. Or some in 21, my lord.
With that appointment of 2000.
Yes, yes, my lord.
And that appointment was accepted.
Yes, my lord. It was accepted.
Joining was accepted even
Yes,
after expiry of those.
Yes, my lord.
Okay, who accepted that?
The DDSE.
The present one.
Yes, ma'am. Therefore, during the course of investigation, it was found that there was connivance between the DDSE and the then director, madam.
Okay, so the appointment, as per the record, appointment was issued in some 2018.
It starts from 2017 till 19, madam.
Okay, none of them have joined.
Some of them joined, some of did not join, but there are so many illegal appointees who were facilitated by the alleged accused persons so that they could join later, my lord.
Okay.
And since it was an illegal appointment, my lord, and it was kept at abeyance, my lord. So the deputy commissioner, he came to know about it and he filed a complaint. And thereafter the investigation started, my lord. And it was found that all these persons were illegally appointed.
Okay.
There was no interview, nothing.
Nothing.
No DPC. My lord will kindly, there is a status report from the IO, my lord.
Pretty much. Okay. Okay, so these other co-accused were also offered.
Yes, my lord. They've given their 161 statement, my lord. It is very clear in the 161 statement, my lord.
161 statement.
Yes, my lord. My lord, we find it in the CD, my lord.
Okay.
I flagged it, my lord. Flagged it. Yes. You did not flag you.
161 statement of the accused persons were also.
Accused and the co-accused, my lord.
Okay.
And in total, my lord, in this case, my lord, 5 persons were arrested, my lord. 4 have been released on bail, man.
So the 161 statement of the co-accused
Yes, my lord.
revealed that the involvement of the.
My lord, we find it in.
Any one of them have become approver?
No, not yet, my lord.
What is the name of this accused? Igodoy.
Ego.
Okay.
Igodoy. Nine.
So if the director elementary, because it says the director elementary education also appointed. And then also this DDSC is also appointed. Throw, okay.
Yes, ma'am.
Hmm. Who is the husband of the cashier? Who lodged complaint against those appointees?
No, he was the UDC come cashier at that point of time, my lord.
Okay,
But however, in the later stage, my lord, the wife also, he also got involved in this scheme, my lord.
okay,
And one of his daughters were
appointed.
appointed.
So they were also arrested.
Yes, my lord. Not appointees, my lord, but the officials, my lord.
Okay. Whether any of the appointees or also were,
No, my lord.
appointed? No.
No, my lord.
So whether any money trail involvement found?
Not yet, my lord.
Okay,
There is a
but only the.
yes, my lord. But there are statement which says, my lord, money was paid to them. My lord. It's in the CD, my lord. The 161 statement reveals, my lord.
Okay. Just a minute. Okay. So after appointing, if it was illegal appointment without any sanctioning or without any interview, so thereafter, after joining, whether they have received a salary?
Yes, madam. They have received.
Okay.
Now they have been terminated, madam.
Now they haven't terminated.
Terminated.
Okay. Salary, how, is there any report that where from their salary could be managed by the
Ye-
department?
Yes, madam. No, from the education department, madam.
Education department?
Yes, madam.
And the salary came in their name, against their name,
Yes, madam.
from the government?
Yes, madam.
And this. So they were appointed against the sanction post?
Some are like against the sanction post, but some since they were vacant posts, but there are standing orders, my lord, where it says now every appointment has to be done by the APSSB, my lord, through APSSB.
Okay.
But they were directly appointed.
But that is why I'm wondering how their salary came. Because if appointment, if there is a sanction post, appointment, the salary will come against the sanction post only.
Therefore, my lord, that is the biggest part, my lord, and that is
Okay.
what has to be brought into records, my lord,
Mhm.
and that is the part of the investigation, madam.
So police custody, I think, no, he was under the police custody also,
My lord,
now under judicial custody.
my lord.
You want him, why you want him now? So he is likely to be convicted.
Not exactly, my lord, but then since as per the comments of the IO, my lord,
Hmm.
it seems, my lord, he's not revealing the money trail, whether
But now he can't.
he can, oh, obviously, he can't,
They need to obtain a permission from the court,
my lord.
even for the interrogation. Now, since he is in the judicial custody. Can that be the reason for further detention?
No, my lord, but
Okay, so he appoint them in his own level. At his own level by violating the rules. He also confessed his guilt. Whether these the other witnesses also or anyone one of them have given any statement before the magistrate?
no, my lord, not yet, my lord.
Okay, so only before the police only.
Yes, my lord.
So he promised to give money also.
My lord.
Okay. And then the director also stated that you prepared, except of course for you, the appointment letter. Whether once Little Bagra Doi was also arrested,
No, madam,
not arrested.
not arrested, madam. She is the wife of the accused petitioner, madam.
Okay, okay.
She is the wife.
So there is.
Mhm.
Now, by now, probably whole entire or all the relevant papers must have been seized.
There is a, madam.
So, you want me to see the statement, 161 statement,
They have admitted, my lord, 161, they have admitted of giving money and taking money.
money also?
Yes, my lord. They have admitted in the 161. The other co-accused persons, my lord, who were released on bail, my lord,
Hmm.
they have admitted that they have given money.
Okay.
That is there,
And
my lord.
what is the statement of this accused?
Accused, my lord, निकाल देगा.
And a monk who stated that money has been given
Everybody,
to
all,
the-
maximum, probably all of them, my lord.
all of them.
Yes. All of
Okay.
them, the other co-accused men.
Okay.
निकल गया.
Whether this accused person was in the custody, inside the custody, whether he is in the inside the custody or in the hospital,
No, he's in judicial custody.
judicial custody. And what about this director?
Director, my lord, in total, my lord, there were 13 cases were filed against the director, my lord. In 2 of the cases, my lord, in respect of Longding district and Anjao district, my lord, he has been released on, he has got bail, my lord.
Okay.
But remaining 11, my lord, it is fixed today, my
So
lord.
he is also inside.
No, my lord, he has filed an anticipatory bail, my lord,
In all the case.
in all the other cases, my lord, which is fixed.
In two of the cases where he was arrested, he had
No, he was not arrested, my lord.
not arrested.
In one, he was arrested. In another, he has filed an anticipatory bail, my lord, which was regular, made absolute, my lord.
Okay.
Four arrest order. Tapi kau mau.
One case, he was arrested.
He was arrested. Tapi
In
kau
one,
was
but on medical ground, he was released on bail.
Okay, so he
Because-
has not yet been interrogated.
No, he has been interrogated.
Interrogated.
Yes, madam.
Okay. Whether the charge sheet is ready.
No, my lord. Not yet, my lord.
So the status of the case is still under investigation.
My lord.
Some more are to be arrested or all the arrest has been made. Arrest has been made. All the accused.
That, I don't have any comment, I mean, instruction on that, my lord.
Okay.
Yeah, no.
So status of the cases they have they given?
Yes, my lord. I place it, my lord. The small one, which my lord, absolutely right,
It's
my
too
lord.
long to go through.
Because the CD is quite large enough, my lord.
Hmm?
The CD is very big, my lord, therefore, understand.
Yeah. It will take time.
My lord.
So finally status, where do we find the status?
My lord, the status which I have given you, my lord,
This
which
is in
you,
respect of this case, this person only.
yeah, this, however, my lord, only in respect of this accused person, my lord.
Hmm.
But the investigation remains that
How many of them are still inside the custody? All of them?
oh,
Total, how many have been arrested?
total 5, my lord.
5 arrested.
5 arrested. 4 have been released on bail. Now this is
Okay.
his remaining, my lord.
Okay. So 4 were have been released on what ground?
Because, my lord, their custodial interrogation was not necessary, my lord. As
Okay.
per the order, my lord,
They have given
yeah,
given the
they have
statement.
annexed it in the I that they have filed.
161 they have given.
Yes, my lord.
Hmm. And then, okay.
Considering the case, my lord, since it's a very serious matter, my lord. However, my lord, considering the fact that, my lord, he has been under custody for the last 73 days, my lord, and except for 409, my lord.
All they have been done as per the instruction of this authority. This other co-accused.
Yes, my
It
lord.
appears.
My lord will find it in the additional affidavit filed by the accused petitioner, my lord.
UDC.
Page 10, my lord. It starts from page 10, my lord. Additional affidavit, my lord. Additional.
bail order. Bail order.
Page.
Starts from page 10, my lord.
This is bail,
Yeah,
Ah.
this is the bail,
bail order.
yes.
Bail order.
Now, this co-accused was serving as a LDC. There are 4, my lord.
Tuan-tuan dia lakukan. Tuan-tuan jangan lakukan.
Kalau police custody.
14 days.
Even if there on face before the police also, it doesn't mean that it will stand.
Yes, my lord. There is,
It
yeah,
will
my
go,
lord.
it will go,
They will go, but the consideration was that, my lord, since
they
the,
will turn hostile, and that cannot be the ground force.
no, this bail was allowed. Why? Because, my lord, at the time of arrest, my lord, right away he was sent to the police custody, sorry, judicial custody, my lord. He was not taken into custody.
But then there's a lot of allegation against you. All these statements of the other co-accused are focused, directed towards you only. Very difficult.
Now, my submission here indicates is that though the allegation is made, entirety of the allegation is based on the documentary evidence. Now, whatever appointment was made, all of them have been seized. And I too have also given statement under section 161 of CRPC. Then, after arrest, I was kept in the police custody for 14 days. After expiry of the 14 days, I have been remanded to the judicial custody. After remanded to the judicial custody, the IO has never sought any prayer that the accused to be remanded for custodial interrogation. There is no such custodial interrogation after remanded to the judicial custody. Neither the IO has made any prayer before the court that they will do any custodial interrogation to the accused person. But nothing has not done, nor they have not made any prayer that they need custodial interrogation to this very accused. There is, and what, apart from that, I have been transferred out from Sangla. I am no more the Deputy Director of School Education of Sangla. I have been transferred to Pucha. So there is no question of tampering of the document. There is no question of the threaten to the witnesses.
You are not yet retired?
No, I am not yet retired.
Okay.
I have been transferred out. Now I am in different district. And nowhere in the police statement, they never said that I would jump over if I will be granted on bail or I'll not attend the court. Now, the basic object and purpose of bail is to ensure the attendance of the accused to attend in the trial. So I am ensured that I'll pass the trial.
Now the IF says there is a possibility of you're inducing.
But I am in different
Since-
district.
Since the case is still under investigation. You have been in authority and are in the authority.
And the co-accused statement is not a substantial evidence. And moreover, the co-accused statement made before under section 161 CRPC is not admissible because the person who is being against me, he himself is also an accused. Therefore, the statement made by the co-accused is not admissible. So, today, in support of my submission, I will give some rule. There is 2020 volume 4 HCC 646 P. Chidambaram versus Directorate of Enforcement, that is para 23, para 30. Para 30, it is very clear that para 30. Further, it is noticed that one of the co-accused has been granted bail by the High Court while the other co-accused is enjoying interim protection from arrest. The appellant is at about 74 years and as noted by the High Court itself in its order, the appellant has already suffered 2 bout illness during the incarceration and was put to antibiotic and has been advised to take steroid of maximum strength. 23 in the para 23. Para 23. Thus, from cumulative perusal of the judgment cited in on either side, including the one rendered by the constitution bench of this court, it could be deduced that the basic jurisprudence relating to bail remains the same in as much as the grant of bail is the rule and refuse is the exception, so as to ensure that the accused has the opportunity of securing fair trial. Now, that is another ruling is HCC 22 online para 14, 15, 16. 14. However, serious the offense may be, the health condition of a human being is paramount. The custody during the period of investigation cannot be termed to be the punitive in nature. The health concern of a person in custody has to be taken care of by the state and keenly watched by the judiciary. Even every person has a right to get himself acquainted adequately and effectively medically treated. Now, Article 21 of the Constitution not only gives a fundamental right, but right to live with dignity, right to live a healthy life is also one of the facets of fundamental right granted by the Constitution of this country. Now, para 16, the kind of ailment which have been informed that the petitioner suffering from are really very painful and need immediate redressal. Therefore, this court, without going into the merits of the case, and only on a limited point that led to the petitioner get his suitable neurologist examine conducted, he is inclined to grant the interim bail on medical ground. Now, another is 2023 HCC online. Para 3. After hearing learned counsel for the parties, at present there is no reason to disbelieve the report of G.B. Pant Institute of Postgraduate Medical Education and Research. We think it appropriate that the citizen is having a right to take treatment of his choice at his own expenses in a private hospital. Now, these few links, I think it cover up.
Okay, so I'll pass over, and if reject, we'll ensure that the proper treatment is given. Mr. Mukherjee, non-counsel for the petitioner, and Mukherjee, non-senior counsel, assisted by Mr.
KW.
KW, non-counsel for the petitioner. Also had Mr. Ojing Pada, standing counsel, SIC. Okay, I'll pass over.
My lord.
Keep this in the chamber. Oh.
May I proceed, my lord?
Yes.
My lord, this is a bail application under section 439 CRPC. Praying for granting a regular bail. And it is a subsequent bail application. My earlier bail application has been rejected by the learned session judge UPR. That is on page 28, my lord. This is a case registered under 302, read with section 34 IPC. My lord,
Section
302, my lord.
302.
Yes. My lord, this is a,
Let us see the FIR.
yes. FR is at page 15, my lord. This is a FIR lodged by a,
Okay, so I think CD was called for.
Yes, Your
Is
Lordship.
there any material against the accused?
Yes, Your Lordship. At this stage, Your Lordship, they have come with a prayer that there was an order by the DDSC, Your Lordship, UPR, that an exam has to be conducted in the school, Your Lordship. I've been informed that the exam has already been conducted. It has been, it was conducted on 25th to 30. The exam part has been done, Your Lordship. The other part, Your Lordship, is that there is an objection, Your Lordship. I have flag marked the objection of the IO.
On what ground?
On the ground that since there are other witnesses, Your Lordship. Those has to be examined because all the witnesses are juveniles, Your Lordship. And also,
Couple took place in between the students only.
yes, Your Lordship, but then there are,
Are they involved in any case? Anyway, directly, indirectly? Directly is of course clear, of course, apparently. they can't.
apparently they are not, Your Lordship.
And then indirectly, how they are involved?
Because the statement given by the accusers, the alleged accusers, Your Lordship, they are not corroborating with each other, Your Lordship.
No. If corroborate, what is the result? Say, for example, who has stated what,
Your Lordship will see
And
that
which-
immediate,
which act, from which we could understand that there is an incriminating material against a particular.
yes, Your Lordship. Firstly,
Against which of the accused? If there is any incriminating material that they are also involved.
no, their direct involvement is not there, Your Lordship.
Okay, then
That's very apparent, Your Lordship. The other thing is,
what's for their custody?
first of all, Your Lordship, the driver is still absconding, Your Lordship. The statement of the school owner is not being taken, Your Lordship. The other thing is that all the three of them, at
could
that
be-
point
that
of
could be
time,
Because of out of fear. also.
yes, all three of them, they were at that point of time in the residence, Your Lordship. No,
And then-
in the residence, the school residence, Your Lordship.
Okay.
They were given the information. They did not take the disease for proper medication, Your Lordship. The parents was misled by them, Your Lordship, while they were taken to the disease was taken to the medical, Your Lordship.
Not taken to, but on the way only, while the disease were being taken to the hospital, on
Yes.
the way only they met.
On the way only they met, Your Lordship.
Hmm.
First of all, no
They-
proper information was given, Your Lordship.
Hmm?
No proper information was given to the parents, Your Lordship.
Hmm.
Your Lordship is well aware if an authority in a school of boarding school, Your Lordship, such
Okay.
kind of thing happens, Your Lordship. It's the duty.
Immediately after, I think immediately after the incident, the telephone,
Mm.
they informed through telephone.
Exactly, Your Lordship. That information, Your Lordship, was not properly given, Your Lordship.
Hmm.
They were just informed that she has so and so has happened. They did not even specify the criticalness of this, Your Lordship. Now she was taken to the Nirjuli, Your Lordship. Subsequently, she was diverted to the Dreams, Your Lordship. Immediate medical care was not taken. Even the doctor was present in the compound, Your Lordship. The doctor in the school who was a doctor in the school, Your Lordship.
Doctor was not called.
He was called for, Your Lordship.
Called.
On his instruction, they were
Okay.
taken, Your Lordship.
Then, what are allegation against them?
The other thing is, Your Lordship, that my objection as per the objection given by the IO, Your Lordship.
Hmm.
All three of them are not from the state, Your Lordship.
Not?
From the state.
Okay.
Not from the state, Your Lordship. All of three of them, since there are still a statement of, because after the incident, the school was closed, Your Lordship.
Okay.
The statement of some of the,
The school are being run by them.
yes, Your Lordship.
Okay, they are the owner of the school.
No, not the owner,
No,
only the employees. Therefore, I said the
Okay.
statement of even the owner is yet to be taken, Your Lordship.
Hmm.
Now, when the school was closed, Your
When the
Lordship,
incident took place?
it took place on
First March.
1st of March, Your Lordship.
Okay.
Your Lordship will see even the driver who had taken the victim at that point of time to the medical, Your Lordship, is still absconding to this date.
Maybe because of fear.
Yes.
Because the person died.
The other objection that the IO has given is that
What about the juvenile in conflict with law?
they are sent to the juvenile homes, Your Lordship.
Okay.
Three of the alleged accusers, juvenile.
Three of them.
Three of them, Your Lordship.
Oh.
Now, also, Your Lordship, since the statement, because the eyewitnesses were obviously the students who were present in the hostel, Your Lordship.
Hmm.
All of them had left the school, Your Lordship. Now, their statement is also to be taken into consideration. Now, therefore, the objection that since they are having an upper hand and they are the authority of the school, Your Lordship, having a proper command of.
Say that the school is closed.
Yeah, after examination, the school has been closed, Your Lordship.
Hmm.
There was a direction for conducting of.
Their statement will be recorded.
Yes.
Individually.
Yes,
By
therefore,
quoting them or by going there.
therefore, only the statement of if the other witnesses is completed, Your Lordship.
Hmm.
Only till that there is a objection for the bail.
Now, what inducement can they do? Say, for example, if given, even if they stay, if the students also are allowed to stay in a hostel, if they stay together also, what kind of investment, say for example, likely to be?
Your Lordship, since the students are much more aware of and have
Because
these
you said
principals and wardens,
admittedly, they are not involved.
yes,
Then
there are chances that they may influence the victims, influence the witnesses.
have you got the statement of this juvenile in conflict with law?
Yes, Your Lordship.
They probably has admitted no.
No, not exactly admitted. They have been putting
But-
blames upon each other, Your Lordship.
Okay.
That's
So, but then it was among them only.
among them only.
Okay.
There is no denial on
And
that.
probably-
There is no denial on that. Even for the IO, Your Lordship, there is no denial that it was between the student. The only involvement of these alleged accusers were that, being the authority of the school, no fast actions were taken, Your Lordship. Even the parents were misled, Your Lordship. If a proper care,
Deliberately.
and even the CCTV, Your Lordship, that was a prime witnesses in any case of such nature, Your Lordship.
Deliberately with the intention that let the person die, that cannot be.
Yes,
That may not be
yes.
possible at all.
Yes, yes, I completely.
Why do we want? Why the police want them?
There is a specific objection stating that since they have a very control over the students, Your Lordship, since one of them being the principal, one being the warden,
Probably has all of them have given their statement by now.
there is nothing as such that if they are not in the school, the principal would not be making any influences, Your Lordship. They are well aware of the parents, they are well aware of the addresses.
Now, nothing prevent the police to take statement of the students
Half of
now.
the statement has been taken, Your Lordship.
Hmm?
Some of the students' statements have been taken.
That is why, as of now, nothing prevents them to record their statement. It's a question of only 1-2 days.
Yes, Your Lordship, and
Right.
therefore,
That cannot be the reason.
therefore, the investigation is still going on, Your Lordship.
Think,
Otherwise, there is a objection by the IO, Your Lordship. Clearly admitting
on what ground?
the specific ground has been meticulously given in
Where
the.
do I find the objection?
These are.
Okay. How long they have been there inside?
30 days.
30 days.
Yes, madam. We were arrested on 3rd March. And remanded to judicial custody on 6th. And on 6th, I was specifically mentioned that our custodial interrogation was not necessary. So we are sent to judicial custody.
Let me know because they are not involved. Only inactive if there is any. Not very active. Could have taken but then could they also say, supposing if some 5-10 minutes earlier had they brought them,
First of all, Your Lordship,
Yes.
see,
whether the postmortem done?
yes, it has been done.
Okay.
The cause of death has also been given. It's in the
Okay.
CD. Your Lordship.
So any indication that he or she could have been saved?
Yes, there is an indication that she could have been brought earlier to that effect. Your
Earlier timing?
Timing is given in the CD. Your Lordship. Because she was first rushed to the. First of all, she was.
She was attended by the doctor.
In the school, and then she was referred to the Nirjuli, Your Lordship. Therefore, from Nirjuli, she was taken to the TRIMS, Your Lordship. The only excuse given by the concerned authority was that she was transferred to Nirjuli. Nirjuli is a CSC, Your Lordship. It's well over. She is CSC, Your Lordship. Nirjuli, just because her parents were a resident of Nirjuli. And then she was brought to TRIMS. When she was brought to TRIMS, Your Lordship, she was already declared dead. The statement of the children's that subsequently after those injury on her back, Your Lordship, she started having those breathing problem. There was clear visibility of blueness in the leaves, Your Lordship. All those statements, and therefore they called the warden and the principal, Your Lordship. Now, my fair submission is, Your Lordship, that there is no direct involvement. However, Your Lordship will see they might not in the trial, they might not be under 302, Your Lordship,
Not
but
possible.
not possible at all, Your Lordship. But Your Lordship will see when the children are given in the school under the guardian of the school authority, Your Lordship, it is the authority's responsibility to take a swift decision and swift action, Your Lordship, which has not been done.
How soon
And
is the question?
yes, therefore, Your Lordship will see in the CD, Your Lordship.
So, let us see at about what time the incident took place and what time they have started or acted or they brought the.
Times are not
That's
specified.
Not specified.
They're not specified with
So
any
that
of
is-
the
that is the
161.
only important, if they have made an undue delay, then only, of course, they can be brought that, say, of course, that there has been a negligence on the part of the authority.
The
Otherwise, you see, it's very-
FIR.
Otherwise, it will be very difficult and very difficult for any person to run
Yes,
school also.
yes, because as per the statement of all the victims and the alleged accusers, Your Lordship,
Hmm.
the time given is not specific.
Okay.
However, if Your Lordship will see the FIR itself, there is a clear mention of the negligence of the school authorities.
Where?
FIR is at page number 15, Your Lordship.
Okay, okay. So these are the only authority in the school? All the authority have been arrested?
No, they were the ones who were informed, Your Lordship. The children have informed them.
Okay.
These three were the people who were the first attendee of the deceased person. Your Lordship.
Okay, so they are the responsible person to take care of all those things?
Yes.
Okay, they are in the rank
The-
of, means what designation they have there? in the school?
One is the principal, Your Lordship.
Okay,
One is the
principal,
academic
that's it.
dean, Your Lordship.
One is,
Academic dean, Your Lordship, was also present at the place of occurrence
okay,
at a point of time. And one is the warden, Your Lordship.
warden. So this incident took place after school or during the school time?
It happened in the evening after the school, most
Okay.
probably, Your Lordship.
Okay.
My lord, incident took place at around 9:30 PM.
PM,
Yes. So we generally put up the lights of the hostel at 9 PM, my lord. So incident took place after light up. So we, accordingly, as soon as we got the information, we informed the parents, and it is revealed in the FIR also. Father has clearly stated that on receive information from us, he asked us to brought this victim to the nearest hospital. So Alphabet Hospital usually is the nearest from Doimuk. So driver of the bus, we have speedily taken to the victim to the hospital, and on the way only we met the parent also.
actually, the informant was informed about the incident at about 10:13 PM.
Your Lordship will see
If the
FIR at
incident took place after the light
9.
put off, at 9.
We are not aware of the light situation, if
Okay.
it was put off or not. Your Lordship will,
Okay.
in that case, come to page number 15, Your Lordship.
Hmm.
The FIR, because the FIR was filed by one Vishnu Hinia.
Hmm.
Your Lordship will see she's the mother, she's the father of the deceased, Your Lordship.
Yes.
Father of the deceased has, when he had got the call from the principal, what were the reasons explained, Your Lordship, and the entire detail has been given by her, by him in the FIR. Along with the timing, Your Lordship.
Unconscious condition. What is the ground for the objection? This could evidence that. So how long has the IO indicated how long it will take to record the statement of the students?
There is no reference to that. Your
No.
Lordship.
So I think with of course the strict condition that they will not leave the
Jurisdiction of this.
jurisdiction till the completion of the investigation and then furnish adequate bail. I think that should be.
And not tempering, because since
Can't-
he has
not
all
with
the
any of the students.
authority with regard to even CCTV whatsoever is in the school, which might be
Okay.
taken into consideration.
CCTV was also there.
Yes, there was
It was
CCTV.
not
It was not functioning.
It was under them.
Yes,
No, under them means
it, because
the
the principal,
purchase of installation of CCTV or making them.
it was under the authority of the principal,
Authority or the owner.
of the principal, Your Lordship. Your Lordship, owner, what they does is they will install the CCTV.
Okay.
It's the duty of the principal to look into it that all the amenities provided in the school is functioning or
But
not.
then at night they switch off. My lord.
Or that's not proven if that was switch off or it was, but then CCTV was not working.
Hmm.
That's the thing. It was.
But the entire light switch off, then the CCTV also. will-
No, Your Lordship will see the switch off of light is their statement.
The entire light if it goes.
That's why
It
the
goes.
statement of switching off the light at 9 o'clock in the evening is their statement before this honorable court, Your
Okay.
Lordship. There is no statement even by the juvenile witnesses.
Not in 161.
Nothing as such that there is a timing of switching off the light or anything.
There 161 has also come here.
Some of students 161 has come.
No, no.
The alleged accused, juvenile accused, yes, has come here.
What they stated.
There was actually a scuffle between one of the student had actually mocked certain features of her facial features
Okay.
with her friends, Your Lordship. That's when the deceased was also upset and they were having a verbal argument, Your Lordship. And during that time, there was a push and pull, and subsequently one of the senior making inquiry that they should not be fighting on the next attempt got angry and had bashed her from the backside to both the alleged accused as well as to the deceased, Your Lordship.
Mhm.
Unfortunately, it might have got into the wrong part of the body. That's when, and it was the reaction was very quick and the effect was very immediate.
Okay.
The school authorities in this are only with regard to the negligence. I have already.
Then then naturally, definitely not under 302.
And not
Maybe
negli-
some other
Yes, yes,
negligence is some other.
yes,
Maybe it comes under bailable.
yes, yes.
Hmm.
My lord, CCTV was not installed in the girls' hostel especially to maintain privacy. CCTV footage is installed at the entrance and boys' hostel only.
Mr.
And
Sago, counsel for the petitioner. Also heard Miss
Tijini, Your Lordship.
Ginny. PP. This is an application under section 439 CRPC 1973, praying for granting of regular bail to the accused, accused person, namely Ms. Pamsangla Wasan. She is from
Manipur, my lord.
out of state.
All are from Manipur.
There is,
Out of-
out of state. Who has been arrested in connection with BMKPS case number 1324 under section 302 34 IPC. The case of the petitioner is that one Sri Navam Vishnu Hina law is an FIR before the OCPS. Move. On 2/3/2024 against the C is the principal.
Yes. Warden and principal female.
No, this one,
She is a hostel warden.
this is not a principal.
No, not principal.
Your Lordship, item number
Their
Four
condition
is- Item number 4 is the warden. Item number 5 is the academic dean. And item number 6 is the principal. Yes.
We'll take up 6, huh? We'll be paid in 6. 6. Against the principal, hostel warden, caretaker, and 2 girl students of Rising Star International School, MG, under MG. Alleging the murder of his daughter inside the school. School hostel, inside the hostel. Huh? Stop. The informant, his father, alleged that on 1/3/2024 at about 10:13 p.m. while he was watching TV, the principal of Rising Star International School, MT, called him and informed that his daughter is under unconscious condition. on which the informant told her to immediately take his daughter to nearby hospital. And when he rushed towards the school, on the way, they saw the school bus. And by overtaking the school bus, they stopped the vehicle and saw his daughter was already dead. The death of his daughter was confirmed by the doctor. Of the said school. And at Freeze, Nahalagan. So, basing on the above allegation, basing on the above allegation, the police has registered the above case and arrested the accused on when she was arrested. 3/03/02/2024. And since then, the accused is under the custody. So, you have filed bail application before the client,
Yes.
session court also.
Yes, madam.
For how many times? Once.
Once.
It was rejected.
Rejected.
On what ground?
No, no, it was not fine only for once, it was fine thrice.
No. It's the second time.
No.
Yeah.
One, it's at page number 23.
You filed bail application before the session court.
Yes. That was
Did you
rejected
file
on-
subsequent bail application before the session court after that?
No,
after
no,
rejection?
no.
Okay, only once it was rejected.
Only once.
Where is the rejection order?
Rejection order is
Your Lordship will find at page number 23. I'm not aware if
Okay.
I'm reading it mistakenly or because
Page-
120 on 4/3 immediately.
It was 4/3, yes, 4/3.
Oh, this is a reminder.
rejection order is, my lord, at page 28.
Hmm?
Page 28 of my application.
No, the 4/3 is, I think, the remand order.
Remand.
This is by JMFC.
Yes, it's at page number 28.
Yes.
So rejection order, rejected on what ground?
That,
At page number 20, down below, Your Lordship will see 28. Start with paragraph 2, Your Lordship.
Okay. Okay.
Lordship will see also the part of the CCTV that was given has also been reflected in the
Hmm.
that he apparently seems to have stated
It
that
seems,
he forgot the password of the CCTV.
oh. Anyway, we'll resume it too. So this, I'll pass an order. Okay.
Lordship
So
also,
even if pass order also, grant also, but then of course.
With a strict condition, Your
strict
Lordship.
condition will be imposed
Al-
upon them.
also, Your Lordship, there is this, if I may specifically pray that
Hmm.
if the school wardens, Your Lordship is, if, first of all, without the permission of the court, Your Lordship.
Without permission of the court or the police?
IO,
Your
Your
IO.
Lordship. And then
They will not leave.
yes, if Your Lordship also direct them to appear before the IO on every
Yes.
second week,
Every Monday
Monday.
at about 10:30.
Yes,
Hmm.
yes, that would also suffice, Your Lordship.
Okay.
Also, Your Lordship, because since they're in a very upper hand level, Your Lordship, in the sense like they,
Hmm.
much, they are the principal of the students, Your Lordship.
Mm.
So tempering and also not
That
influencing the
will ensure-
witnesses.
That will ensure,
Yes,
that will ensure that they will also not contact with any of the.
any of the students, Your Lordship.
That will ensure, yes. So it-
Also,
all the three bail applications.
yes.
Anything? Yes, these three application will dispose of, okay, yes.
No, no, I wanted to mention a matter earlier in the morning. I was mentioning in the
Okay,
report
which
number
one?
one.
Item?
CRP 10 of 2024.
Item
To be
10.
taken up today on.
Hmm?
No, it is not been listed today. It is only for passing a order for service of notice upon respondents. CRP 10 of 2024. It has not been listed today. So
Not
it may be
listed
taken up after lunchtime.
after lunch.
Yes.
Can it be listed? Can it be brought? Last, huh? What is this
CRP?
matter about?
It is a civil revision petition.
Huh? Yeah, it can be.
It is only for
Then,
passing an order
okay,
for notice.
okay.
Obliged.
Your Lordship, if the CD is being written
CD will be returned, huh?
after, tomorrow,
After
I'll
passing
take-
order,
I'll
after
take the-
passing order.
yes.
Okay. Most obliged.
May I please, Lordship?
Yes.
Lordship, here the applicant is seeking 438 of CRPC.
Heavy.
Yes, Lordship. Lordship, brief facts is that some illegal appointment were done as alleged in the affair that I was the director. That then
This is the director in the
Yes.
morning case.
Yes.
Okay.
Lordship, I was granted bail in the first case, in the laundering case. Yes, that is why there are so many cases. However, the crux is same. The main
In how many cases you are in bail?
in two cases.
Two cases.
Yes.
Regular bail.
One was AB, one was regular bail.
Okay.
The
One
first
regular bail in which district?
it was in pertain to Anjao district.
Anjao.
Yes.
So how long he was there in that case?
For 15 to 20 days, almost 20 days.
Okay. On what ground he was released?
During his stay at the police custody, he was already suffering from this heart alignment. Angioplasty is done. That one stent has been put inside this before all this case has been registered.
Hmm.
So while he was in police custody, his health deteriorated, and on that ground he was granted bail. And moreover, TRIMS they have said that for further examination also, as he has a history.
What is this paper? Admission to room so and so medicine whisper. This is new.
So I have filed one additional affidavit also to showing that his present health status is admitted at Srishti Hospital at Dibrugarh right now also.
So you are
Today-
seeking AV in all the cases or?
Yes, in all the cases, since matter is all same, I have already given my statement, and he was further referred. So I'm already there in the hospital also admitted, and this my medical condition, it is given in the, it is during bail also. It was in the bail application, bail order also. It is clearly reflected that I have a very ongoing health condition. My health, my heart is not at stable condition. May I take your lordship
Just a minute,
to?
what, just a minute. Yes,
Yes, may I take lordship to this page 23 of my
what is
application,
that?
para 13. May I read? It is seen that accused has a history of heart-related alignment and treatment required not being able to provided to him while in custody and his health condition deteriorating. He
This is
was
your submission?
this was observation of the, not submission. This was observation of the this. It's order dated 1/3/2024 by this honorable court.
So this is the bail order where
Yes.
you have been released.
Yes, this is the bail order where I have been released.
This was the first bail application,
This is the second bail application.
second bail application.
Yes.
This was regular bail, not AB. This was for regular bail.
Yes, this was for regular bail. Since 26 to 2024,
24. Now, what is its present status?
present status, sir, I'm still admitted at Srishti Hospital at Dibrugarh.
Whether has he been interrogated?
Yes, my lord.
So, you mean to say interrogation in respect of all the cases completed or what?
My lord, he has been interrogated, my lord, and then
Whether
Yes.
further interrogation, further examination required?
yes, my lord, they'll be requiring, my lord. But since, my lord, he was
You have a latest status report?
yes, my lord. This is the 17th. CD is here, my lord.
Okay,
17 March, my lord.
17 March.
My lord, he was released on bail only on medical ground, my lord.
Okay.
Because at that point of time, he was arrested, my lord. And while he was in custody, my lord, he deteriorated, his health deteriorated, my lord. And then he was shifted to the ICU. That's why the bail was given, my lord.
While in custody.
Yes, my lord.
Yes.
So bail was given because there was a statement or a medical report which says that he has to be taken into a further better institution, my lord. So now it seems like they have filed an IA, my lord. He has been admitted at Dibrugarh, my lord. And now he is still in medical, my lord.
Lordship, in the first case also at the Londing, I was granted anticipatory bail, and which was allowed. The state, they have also they put to challenge before Supreme Court, but however that was also dismissed. Their application before Supreme Court.
So this was against
This was against Londing, the first case.
rejection order, against the rejection order.
Yes, they have
No, against against granting of bail.
bail. Yes.
Okay.
The SIC,
Now,
the
after granting, they normally.
Lordship will find at page 19 or
19 of
19 of the petition
what is that?
that there
Okay. No ground for interference.
Yes.
That is, of course, after granting, very difficult. After appreciation of
Yes.
the material available on
Yes.
records, the court will pass order. It's very difficult to interfere again.
yes, Lord.
But then here in the case, we have to, of course, examine.
So
Now,
here only we have to look, only consideration for today was that whether his health condition, because their apprehension, it has also been dealt with in the bail application.
With regards to health, we are also not expert. What is the latest? If you say so.
It is angioplasty, Lordship. There's stent has to be put inside the this
In
heart.
past, of course, he had that problem, but then this problem, as we know that many people do have this problem.
Yes. And para 24, para 18, page 24, the apprehension that SIC that in regards to tampering is also been dealt with in this bail by this order. Para 18 that married. No?
Yeah.
Further apprehension of Mr. Pada Lanet, standing counsel SIC, is that granting regular bail to the accused may facilitate him to tamper with the evidence, also influence person working in the Director of Elementary Education, Government of Arunachal Pradesh, would be required to dispose as witness in criminal proceeding. The said apprehension has been duly noted. However, given the fact that accused has already been retired from his services on 31/5/2021 at attaining the age of superannuation, he would not have access to the records that will be available in the Director of Elementary Education, Government of Arunachal Pradesh, and or any subordinate officer.
His associate who accused,
Yes.
who are DDSC, they are still in service.
Lordship, in service, DDSC's roles are different. Suppose if I admit that I have appointed, however,
They have still hold
yes,
in the office.
the DDSC, what they have done is that they also took advantage of that. They have some of the
You have opened up the book.
other DDSC, what they have manufactured the appointment letters also, and they have now salary is not on my part. They have misused the salary also, and they have by manipulating that appointment order, they have put their own relatives also. That is not in my case.
But then it appears that since the boss has opened up, boss has started, they must have started. They can
Even
advance
I am the boss. Even for me, secretary is there, special secretary education is there. I am at a different footing. DDS is there at a different footing.
But then as per the this morning we have seen, it is in connivance.
That DDSCs are saying that, however, that is not the case, because DDSC have gone further also in regards to manipulating their service book and salaries also. That is not in my case. So my only point of consideration is that now I have given a statement in all the district, and while I was in custody, my health condition deteriorated, and still I'm in this condition. And last two bail application was also on that ground, health issues.
But now he's not in any case inside. He's not inside under the custody of the
No.
police. Although he's in, of course, in one case he was already released. And
Yes.
in other AB.
AB.
Okay.
And while I was in custody, all these other district have been also been covered. I have given respect to statement in regards to all the districts.
Okay.
Those
Separate-
districts which are,
separately.
yes, those districts which are not even not FIR is not filed. Even in those districts also I have given my statement.
Probably you have admitted
Yes.
on that why you're asking bail.
Those I am saying that I have cooperated. I have cooperated there. Whatever they want, whatever information SIC wanted, I have given them. Now custodial interrogation is not required,
Okay.
and more so because of this health condition.
So is it true that he has given statement in all the PS case or
Yeah.
SIC cases
Yes, my lord.
separately?
Yes, his statement has been taken, my lord. Well, he was in custody, my lord.
Hmm.
He was not on arrest, but then his statement has been taken, my lord. And
So custodial interrogation was also there.
yes,
No.
my lord. Yes, my lord. He was
there
remanded
for all
for
the district.
no, my lord. Since he was not arrested in those districts, my lord. But well, he was arrested in respect of Anjao district, my lord.
He has already given.
Yes, his statement was taken.
So you're asking for the his custody, the police, SIC, whether they are asking for the custody,
Yes, my lord. In the
why it is required? Have they stated?
as far as the merits of the case are concerned, my lord,
Yes,
it is very imminent, my lord. There are apparently he's involved, my lord.
yes.
So there is already in the city, and this morning also, my lord had seen, my lord, this
Mm.
statement, my lord. There is a connivance, my lord. And, submitting fairly, my lord. As far as the medical condition is concerned, my lord, I don't have any comment on that. That's because when they say that he's already admitted in the ICU for an operation, that is here, my lord. But
How or what way he was protected interim as an interim? Has he been protected?
no, my lord. Till now,
Not yet.
not yet, my lord.
Okay.
Not yet.
Lordship, only condition was that whether we were asked to file one affidavit showing his medical condition. Only
Have you
that
filed?
Yes.
Which one? So medical documents using a medical.
Those are only
what
that-
in common parlance you have stated here about the medical condition.
Medical is that he is admitted as receipt is there also. Admission on 33/2023 was admitted.
This city hospital is private.
Yes. Since before registering of all these FIR, I've been doing regular checkup in this hospital only. That was in the first bail application also. It was appreciated also in the first launding. I have gone through that angioplasty also there. Inside the heart, there's one stent is put so that blockage.
When that operation?
So that was way back in more than 1 year before.
That was earlier.
Yes.
Not now.
So Lordship, that stays inside the heart, Lordship. That has to be regularly monitored.
What is this order? Who have? Have you submitted?
This must be
Has it been
said.
submitted by you? What is this? Ashok Kumar.
Yes, Lordship, here in Ashok Kumar in citation, Lordship, in the para 13, Lordship is Oh, that, sorry, 11 and 12. Merit para 11. One good ground which has been persuaded us to exercise our discretion in favor of the appellant is that the appellant has already joined the investigation. He has cooperated in the investigation so far. Para 12 also. There is no gainsaying that custodial interrogation is one of the effective.
Have you annexed latest medical exam report? Yeah.
Yes,
This is
Lordship.
for examination only, I think.
Lordship,
Not
here,
yet examined.
here
Or
it is.
test only, test.
He's admitted. Admitted that is I've given this
So,
one.
for,
33, 2000.
when this bail application was filed,
It was filed also on 6/3 to 2024.
now
Way
still
back.
you say you are showing and annexed the bills only, the.
No, Lordship,
Test.
this is admission slip with along with the bill, Lordship.
So test, what is the test report?
Lordship, he's admitted inside this one.
Maybe. After admission, one
Yes.
can ask for test of anything, everything. So
Lordship,
we are concerned with the result, whether.
Lordship, it was in bail application, it was already appreciated that it was one angioplasty was done. Angioplasty means that one stent has to be put inside the heart. It has to be monitored regularly after
where do we
15,
find that?
20 days.
Where do we find that? Doctor saying so?
Lordship, in my bail application, actually, when I was arrested, it was already appreciated. That's why we have not annexed it. And what I have annexed is that annexure 6, page 32, this is discharge slip by the trims, so that this discharge is not that he is in good condition. This discharge is for that, so that he can avail better medical facilities. This discharge slip is.
No, so you have filed this additional affidavit.
Yes.
Where-
Today only one thing was to be appreciated, that whether he's still in medical or not.
No,
Only
one
that.
can be in a medical without very serious condition also. Huh? We are concerned with whether he will be able to, whether he is a fit person to be kept inside or not.
No, he's not fit to
So
be
how do
kept.
we know? That's why I'm asking. For test, anyone can give for test, anything, any test.
Lordship, actually, this court had already appreciated all the medical condition. That's why we have not annexed it.
That is why I'm saying we do not know, we are not expert. Where is the medical certificate? Where are the medical documents saying that he is serious?
It must be there in the CD also. They should have kept.
Whether the police has found out.
No, man.
During this pendency of this bail application,
No, my lord.
when he was still in the inside the hospital, whether the police has visited him?
No, my lord.
No.
My lord, as
The
per the-
police have admitted him
because,
to trims.
because during the time he was under custody, my
No,
lord.
thereafter, he has not yet been released from the hospital. Since then,
No, he has been released, my lord.
thereafter,
Because bail was
again he has been admitted.
Yes, again he has admitted.
Maybe apprehending that he will be arrested in some other PSK or what?
No, Lordship, what his medical condition is undisputed. That they will also accept it.
And that we know. But what I'm saying is these things, of course, means many people are having this.
Yes,
So what I wanted to know is the present condition.
yes. That's why I have filed
Because,
this petition.
because it is also not fair that one person has done so many things illegal, not only to the individual, affecting the entire society, department. And it's not fair that he has been admitted, he is already a retired person, he has been admitted in medical, he cannot be. No,
Yes.
not on that. So that is why I want to ensure whether he will be able to cooperate.
Yes, he will be.
Because admittedly, you are saying fairly admitted.
Yes.
He has admitted entire thing, everything. Then he's likely to be convicted, you see.
Yes.
Why to release him? So
Lord,
spend some more time.
no, Lordship,
That will minus from your conviction. That will be much better.
the manner they are filing the FIR is that one was filed way back in 2023 September. After 3 months they file one. After 3 months they file one. And there are 25 districts. In this way, by the time they will file charges, this accused person will be in his deathbed.
You have also issued those appointment letter and then asking them not to join now. You have also planned.
No, I'm not. I'm not in
This morning
capacity.
he was submitting that only.
No, that is their
Appointment
position.
order was issued
Yes, my lord.
and it was not joined
They were not.
immediately.
My lord.
Joining is
Join later
not my part, Lordship.
Hmm.
Joining is on DDSC.
DDSA.
Yes,
Okay.
joining, service book, salary, everything.
Okay.
Only my part is that appointment is there, and there is chances
See,
that my appointment may be
Under such circumstances, what do we do? Fairly admitted,
Yeah.
and then can we release? You think that we need to release the person who has already admitted his guilt?
Lordship, to balance the right of the accused and the right to investigation, the accused, let him be present every Monday from morning 9 to evening 4. That can be done.
Morning 9 to evening,
Yes,
you're proposing.
yes, that can be done. And already I am not allowed to leave this jurisdiction of this honorable court without any permission from judicial magistrate. They have been already protected, Lordship. Now it's question of my right, Lordship, my accused right to participate in
It appears that
investigation.
fair enough that he is submitting that he can be from morning to evening.
My lord.
And then since you have already interrogated, and then you also fairly admitted that he has been interrogated in all the cases.
My
How
lord.
many cases against him?
In
It's
total,
now 13.
13 cases.
In 13 cases.
My lord.
So in all 13 cases, if he has already given statement and interrogated while he was still under custody. So, and since he has already been admitted for this, we do not know exactly, of course, what this disease is, what is ailment. No? But then under the circumstances, so what do you say?
No.
What is the
In my
point
humble,
of opposition? Yes.
in my humble submission, my lord, if the bail is considered, my lord, for humbly pray, my lord, the strictest of the conditions should be put up.
That will be done. That is what he is saying.
Yes, my lord.
He himself is saying from morning till evening.
Yes, Lordship, my house is not even 100 meters away from SIC office. SIC, we are these neighbors.
Take bed and there.
I think he needs to shift to the SSC then.
No problem going.
Okay.
Only taking into consider the medical condition.
So because the heart problem, it appears that it is serious. Yes. Yes. This is an application under section 438 of the Code of Criminal Procedure, 1973, praying for grant of pre-arrest bail the applicant filed this application under section 438 of the CRPC, praying for grant of pre-arrest bail, apprehending his arrest in connection with SIC Vigilance ES case number 07/2024 under section 120B, 420, 468, 471, 409 of IPC 1860, read with section 13 within bracket 2 of the PC Act 1988. So, who knows the FIR? You said you have annexed the FIR also.
Lordship, this, and here, this director, the present director, elementary education, on his report, that has been treated as FIR.
Hmm?
The this the present director.
Page 29, madam. 29.
29.
29.
29.
Okay. 29 is the content of the FIR.
Yes,
Yes.
madam. 30 is the list of the case, madam. Page 30.
What is this 27? 27 is the report. What report?
So this is the report submitted in regards to all over Arunachal Pradesh by the.
This is a district-wise segregation of the illegal appointees, madam. Down below, district-wise segregation of the illegal appointees.
Okay.
Down below, my lord, you find the table, my lord. Tirap, Changlang,
Okay.
and how many TGP, PRT, UPC, LDC, and MTS were appointed, madam. And the total numbers of illegal appointees, madam.
This report is after the FIR.
Yes.
Yes, madam.
Okay. And then whether this FIR was registered or the report after receiving of the report. The
This
case
is
was registered.
and then inquiry was done, my lord. And that this complaint was taken as treated as FIR, madam.
Okay, this complaint. And
Yes.
then after this report,
Yes, yes. madam.
Okay. So after this report only it was registered.
Yes, madam.
Okay.
My lord turns to page 31, madam.
Yes.
In view of the above letter number so and so, Itanagar dated 10th of January, originated by so and so, elementary education, Government of Arunachal Pradesh, Itanagar is treated as FIR.
Okay. Basing on the report submitted by the Director of Elementary Education,
My lord.
Government, Arunachal Pradesh, Itanagar, wide number EED .2, sorry, .2, stroke 689, stroke CORR. Is this the number? Yes, CORR, stroke SIC, dash VIG, stroke 2023-24, dated 10/01/2024. Case was registered being the above SIC case was registered. And, the above SIC case being the same, huh? Repeat the same SIGB PS case number 07/2024 under section 6. Okay, repeat, huh? Was registered. So before filing of this anticipatory bail, he was arrested in the other case.
Yes, other.
Okay. It is submitted that earlier, in which case, where have you stated that in connection with which case you have been arrested? Earlier, in connection with SICPS case number
SICPS case
2
number
of 23, madam.
two. This is against 3.
No, this is 7.
7.
7 of 24.
Okay. Earlier,
Page 14, madam.
earlier the petition, okay, earlier the accused applicant was arrested in connection with
No,
it was
No,
case
my lord.
number 0423.
No, my lord. In 04 he was arrested, but then before 04, my lord, his anticipatory bail was regularized in 02.
In 02, AB was granted and
okay.
04, bail was granted.
04 was later.
No,
Yes, later.
Later.
Okay. In connection with which PS case number 02.
Yes.
02/2023 under section 120B, 420, 409, 468, 471 of the IPC, read with section 13(2) of the PC Act 1988. The accused applicant was granted interim anticipatory bail on interim anticipatory bail was granted on
24/8,
24/8/2023,
2023.
which was regularized and made absolute by an order dated
14/9.
granted by this court, which was regularized and made absolute on
14/9/2023.
14/9/2023.
2023.
Okay. And in the accused applicant, accused applicant was also arrested in connection with
04.
04.
04.
These numbers are same.
Yes, everything same. Only 04.
Okay, 04. Number same, huh?
He was arrested 15/2.
Okay, on arrested on 15/2/2023 in
24.
connection 2024 in connection with this number, huh? 04, huh? It is further submitted that since the SIC has registered, how many more?
11 more.
11 more cases
Yes.
against the accused
11.
in connection with the same offense. Uh, 11 more in for all the district.
Not all.
In other district.
Other district.
Okay,
not-
in other district. In connection with the same alleged offense. The applicant apprehend this arrest. Hence, this application for grant of free arrest bail. Stop. Para. Is there age code for has been produced, and I have produced the same. Mr. Opada, Planet Standing Council, SIC. We already submitted that earlier the accused applicant was arrested in connection with 04, that number, entire number. He was released on bail on health ground.
1/3/2024. What did it?
He was released on bail on
24.
1/3/2024 on health ground when the accused applicant was admitted.
Madam.
In which hospital?
Dreams.
At Dreams. Admitted in Procedural hospital, while he was still inside the custody. So thereafter, the accused applicant was taken where?
Since thereafter he was released on bail.
Okay. And he further submits that he further clearly admitted that the accused applicant was also granted interim anticipatory bail in 02, same number. And on which date?
24/8/2020.
24/8/2020. And the same was regularized and made absolute on
14/9/23.
on health ground. Stop. So please, you have filed this additional affidavit. Whether the court permitted you to
Yes.
file additional affidavit,
Yes.
by which order? 19.
19/3.
Considering considering that the petitioner was having a serious ailment and he was undergoing treatment. This court by an order dated 19/3/2024 had directed the land counsel for the applicant to file an affidavit and to bring on record the latest medical prescription indicating the status of his health condition and admission in the hospital. Stop. In compliance of the said order, the applicant, so this land council has filed this additional affidavit and annexed. What is this called? This document?
Worship,
the medical document.
Medical document is that status that he is still admitted at the hospital,
Hmm.
history.
Showing that the accused applicant is still has been admitted in Srishti Hospital and Research Center where
Guwahati,
Dib-
yeah,
Paltan Bazar,
Dibrugarh.
Dibrugarh
Renambavi.
on when?
On 33/24.
On 30/3/2024. Still he is inside.
Yes.
Okay.
At
And since
11.
then
11th.
he is in the said hospital undergoing treatment for his ailment. Where have you stated, you just a while ago you read some sentence where his ailment was observed by the bail application
19.
in the bail
Yes.
disposal order.
Also, we'll find that this page 23. Para 13.
13, 14.
Accused has history of heart.
Stop. The Atlantic Council for the applicant further submits that apart from the present condition of the accused applicant who has been admitted in the Christie Hospital, he has a story of heart-related ailment and the treatment required was not being able to provide him while he was in the custody in connection with the SIC case number 04. No?
Yes,
And his health, where his health condition had deteriorated, for which he was forwarded to forwarded to the Tomorova Institute of Health and Medical Science streams by the police from the police custody. Police custody or from the
Yes, police
judicial custody
No, police custody.
while he was still in police custody.
Yes.
Thereafter, he was not under the judicial custody.
No, ma'am.
From the police custody only he was released.
Yes, madam.
Okay.
But
Police
subsequently, on the
custody.
next day, the police had prayed for judicial custody, but by the time bail was already
For
granted.
treatment. Stop. Considering, I have heard Mr. Bori, sorry, Mr. Bori, land counsel for the petition. Also heard Mr. Opada, land PP. Upon consideration of the entire record, especially the medical documents and the observation made by this court in the earlier bail order and the present medical status of the accused applicant. However, without considering the merit of the case, I am of the view that the accused applicant. Just a minute. This is AB only.
Yes, Lordship. Maybe.
Maybe only. Just leave that. Considering the magnitude of the offense the accused has committed, I am not inclined to grant bail to the accused applicant at this stage. However, considering the serious medical condition as shown in the annexure. This is annexure A of the medical document is annexure
One.
one of the. In the main also you have an annex medical document.
No, only discharge slip I have.
Okay. Annexure one of the main petition,
Yes,
maybe, and then
annexure 6 of the main petition.
annexure six of the main, and then annexure one of the miscellaneous
Additional.
application. Number 42 AP 2024. The interim prayer of the accused applicant. The prayer for granting interim anticipatory bail can be granted accordingly. In the event of the accused applicant is arrested in connection with the above case number, this is 7, no? And then all this SIC, no? 7 of SIC, that number, okay? Entire number. The accused applicant, his name is
Kapilgaon.
Kapilgaon shall be released on interim anticipatory bail on the following terms and conditions. 1, that the accused CRPC shall cooperate with the investigating officer and shall make himself available for interrogation as and when required. Number 2, that the accused applicant shall not directly or indirectly make any inducement, threat, or promise to any person acquainted with the fact of the case so as to dissuade him from disclosing such facts to the court or to any police officer. 3, that the accused applicant shall not leave the jurisdiction of SIC, or what do we say, Itanagar without previous permission of the, it will be police or court?
Special judge.
Huh?
Special judge.
Special?
Judge.
Okay, special judge,
UPR.
UPR. That the accused applicant shall appear before the IO, SIC. It will be
Yes, and when
twice in a week will do, or Twice in a, huh? Twice in a week on every Monday and Thursday at 10:30 a.m. Before that, I'm sorry, yes, I see, before, for how many days? 4 weeks. For 4 weeks, and thereafter, once in a week. That is on every Monday at 10:30 a.m. for another 4 weeks. Okay. And thereafter is thereafter as per the terms and conditions imposed by the eye of the case. That will be verbal.
Well,
Okay, so it is made clear that in case of violation of any of the above terms and conditions, the interim anticipatory bail granted to the accused applicant shall stand automatically cancelled. With the
my lord, the bail bond.
okay.
Surety in bail.
Just a minute. In the above, the allowed shall be allowed on execution of a bail bond of rupees. How much generally earlier put in?
Earlier it was 50,000
50,000.
with two sureties.
1 lakh with 2 sureties. With the following condition. Okay.
Well,
Same order till item 17 of same thing.
All the same.
Yes.
So numbers will be
Only police case number will be different.
different.
I will provide.
Case number, item number, what is the item?
Highly available.
Item 7, how many? Item 7.
This is 7 to 17.
7 to 17. So the numbers will be different. Only the case number. Only case number.
Yes, I will provide it.
Okay.
my lord, the CD may be.
Okay. Return the CD.
Highly available.
Yes.
Please, my lord. My lord, this item number 18 and 19 may be taken up together. These are out of the same PS case, except 2 accused. One accused in one accused is in 18 and one accused in 19.
Okay, same PS case.
Same PS case,
Okay.
out of same file.
Yes.
In fact, after the interim order granted by this honorable court on 21st of the March 24, we
Granted
have
bail?
interim order.
Interim.
Yes,
This is AB.
this is AB. We have appeared before the IO and executed the bail bond imposed by this honorable court, and accordingly, our statement has also been recorded. Therefore, my lord, at this stage, there is no point to we keep the bail to pending, since we have already appeared before the investigation, and the investigation has already recorded the statement of these 2 accused.
Whether the accused applicant has been arrested?
Yes, they has been arrested and released.
Where is the arrest memo?
My lord, this should be in a CD.
Your Lordship, if Your Lordship, if my
And-
learned counsel first submit, Your Lordship, I'll go through the CD.
Okay.
And one thing, my lord, this has been, on the last occasion, this has been adjourned for only then the medical report, MCL was called for. So pertaining,
MLC.
yes,
That was called for by this court.
my lord,
By this court.
by this court, on, my lord, on the submission of the state, my lord, that the state want to ascertain the medical report pertaining what has been cast to the victim. Otherwise, my lord, my submission would be whatever there in the medical report, this is the other aspect. This is up to the merit of the case. But this is the case, my lord, during pendency of this bail, now subsequent development has arisen, and that has been brought before this honorable court in the form of additional affidavit.
You
Well,
file additional affidavit.
my lord.
It's available here.
Yes, this all available, and on the basis of that additional affidavit, the interim order was granted. Now, by that additional affidavit, the accused person, the person who involved in the crime, the allegation is 307, has now admitted.
307?
Yes, this is the case of 307.
Okay,
Now, the accused person who involved in the case has admitted.
just a minute, just a minute, 307. I'm very confused. What is it? Let us see, just for once, let us see the FIR.
Man,
Let me just.
item 19, my lord. Case 13, my lord, FR.
Okay,
My lord, in the FIR, nobody has been mentioned. FIR say, my lord, simply, my lord, that the unidentified person has injured the victim.
victim has been recovered.
My lord, victim has recovered.
What the victim has stated thereafter
Now,
before the police. Whether the victim has revealed the name of the accused person.
no. But the accused person who is not before this honorable court, he admitted that he was the person involved in the case.
Okay, he himself admitted,
Admitted.
stated before the police.
Stated. Whether he stated before the police, I am not on that.
Okay.
Because he is not before this.
Okay, now what is your prayer?
Therefore, my lord, this bail may be, this interim order pass or
On the basis of the interim anticipatory bail, he
Yes.
appeared before the police.
Yes.
But then the police has not shown him arrested also. Whether shown him arrested him
arrested.
and granted also.
Yes, bail bond has also executed. And
Executed also.
executed. At the same time, the statement also recorded.
Okay. TD was called for.
Yes, Your Lordship, if I may, Your Lordship, I'll just brief the entire case, Your Lordship. What has happened was an FIR was filed stating that on 29, Your Lordship will see even the FIR is clearly mentioned that the statement of the victim later on clearly mentioned that there were three boys who first in a bike was asking him for money and the mobile phone, Your Lordship.
Okay.
On him not giving him he not giving the same, Your Lordship, not he was taken to the jungle and he was first assaulted. Subsequently, what happened? Since he was resisting, Your Lordship, they hit him in the back of the head, Your Lordship. He fell unconscious and he gained his conscious only on the next date, Your Lordship. And he was in his subconscious mind, Your Lordship.
Oh.
And he was recovered by another person, Your Lordship, in the jungle, full naked, and he was unconscious. That's when the FIR was filed by the uncle of the victim, Your Lordship. Then victim was taken to the hospital, Your Lordship. He was in coma for almost 10 days, Your Lordship.
Okay.
10 days, Your Lordship.
Coma?
Yes, Your Lordship. Since he was in the head, he did not gain consciousness
Okay.
till he was in the hospital, Your Lordship.
That is why he was unable to reveal the name of the accused.
No, he does not know the accused at all. Now the process, investigation started, Your Lordship.
Okay.
What has happened was, if Your Lordship will see the
What is
previous
the age of the victim, by the way?
age of the victim, Your Lordship, he's an adult, otherwise.
Okay. Okay. Please.
So what has happened was, his mobile, all three of the mobiles were taken, Your Lordship. Now it was a zero evidence case. During the investigation, what they did was the IO has collected the CDR of his lost mobile phone.
Okay.
So during that time, all the calls that was made after the incident was taken into consideration, and thereafter, one of the call was made to certain person who has revealed that so-and-so person has called me from this number.
Okay.
That's where the first accused was found out, Your Lordship. Now, he still to date, this date is absconding, Your Lordship. Now, through another sources, Your Lordship, sources were put to even arrest the particular named person, Your Lordship, whose name was revealed by through the phone call record, Your Lordship. Through human sources, Your Lordship, information was gathered and specific name was revealed through the sources of these two item number 18 and 19 petitioners, Your Lordship. Now, what has happened, Your Lordship? On the last occasion, they came with a settlement agreement between the victim and the accused, all the three accused, Your Lordship. Now, all the three accused, but since it was not on record, an additional affidavit direction was made to file an additional affidavit bringing into those in record, Your Lordship. On the last occasion, only on the condition that if Your Lordship will see the additional affidavit, Lordship will see at page one of the accused, sir, आपका item number 9.
What is this?
The last page, Your Lordship, of item number 19.
Additional affidavit, yeah. Affidavit by the, I think this is. Then affidavit will bring on record that compromise deed.
Yes, compromise. There was a compromise, Your Lordship.
This they have filed in additional affidavit.
During the pendency of the bail petition.
Okay, prior to this, is there any affidavit also? This is additional affidavit. Oh, item 19.
In item number 19, Your Lordship, the bail was granted only at page number 11, Your Lordship will find that 11 of item number 19 of additional affidavit.
Additional. What is that?
Page number 11, Your Lordship.
19?
19.
No,
Sir, आपका 18 है कि 19?
I don't.
9.
think it has
18,
the page
18,
19.
18 in that case.
18 also.
19.
We have to create
18.
page
9.
for 18.
18 है क्या 19?
It is only after 15.
Yes,
So
page
that-
number 11, 11.
11.
Yes.
Okay, come down, huh? Okay, what is this?
At serial number, at page number 12, at serial number 35 is the name of the accused person, Your Lordship.
35.
Yes.
What?
Since
This is what? This is office
since
record?
this is only for the ensuing election, that is on 19th, Your Lordship. A roster was made of the government employees who would be in charge of the during the election process, Your Lordship.
Okay.
Only on this ground that since he is a government employee and therefore the interim bail was granted, Your Lordship. On the last occasion, what has happened was that the court was
This person, this 35 and two.
Hento Gamno.
He is also accused.
he is
Yes.
also he's accused in item number
19.
19, Your
So
Lordship.
he was granted
Interim bail
anticipatory.
only on the ground that he is a government employee, Lord.
He was given a duty in the. Okay, during election.
The other accused was subsequently also granted interim. Now, what has happened, Your Lordship?
Hmm.
During the pendency of this bail,
Hmm.
they made an agreement
Hmm.
between the victim, Your Lordship.
Okay.
Now, after that was never in the IO's record, Your Lordship. After the grant of the interim bail, they have approached the IO with the
Okay, with the
agreement.
agreement.
Now, on the basis of the agreement, re-examination was done of the victim, whosoever signed in the agreement, Your Lordship, and also of both the accused, Your Lordship. I have just placed the
Agreement.
not agreement, Your Lordship, CD.
He did.
Yes, Your Lordship.
Okay.
There will be two CDs, Your Lordship. First CD, if Your Lordship take up, Your Lordship, the first CD.
Yes.
If Your Lordship come to page number 23.
23.
I deeply apologize, Your Lordship. If Your Lordship come to page number 20.
Right. He is the statement of.
Yes,
the-
25, Your Lordship. He is the victim, Your Lordship.
Okay.
Your Lordship will see that 3 persons started asking for money, misbehaving with me.
Just
So
a
and so.
minute, huh?
And the person who had found him is at page number 24.
3 persons start asking for money and misbehaving with me. So he doesn't know the identity of these 3 persons.
Yes. Now,
They start beating me from National Highway and took me inside. One of them hit on my head from back side. I found myself. Okay.
Now, there was a, after the recognition of the first of the victim and subsequent identification of the, if your lordship will come to then page number 13,
So, when the incident took place,
29th,
so he was recovered on the next day.
next date.
Okay.
Till then he was, and even after, when he was recorded.
And then when this was recorded, do you have the case diary?
Yes, yes, your lordship.
When his statement was recorded?
Yes, your lordship.
Incident took place on 19.
29th, your lordship.
29. So he
29.
was recovered on
30.
30. 29/3 or 29/2. February,
January, your lordship.
January. Okay.
Their statements were taken on, if I may take your lordship.
Statement was recorded on, because you said that he was under coma for 10 days.
Yes, your lordship.
Definitely not within this 9th of January.
Yes.
Must be thereafter only. Shall we say?
On 14th of February, your lordship will find at page number 10,
Please stain of your
CD, your lordship. The second column.
second column.
Yes.
Place of
Above is the date, 14th of February, 2024.
okay, statement of victim. So this was on
14th of February, 2024. Above, your lordship, the date is given.
yes.
Yes.
Series 6 14.
14th of
Yes,
February.
only after
2024.
that.
Yes, only after that, your lordship.
So
Now-
is there any where
Yes. Now-
is the record that during this he was recovered under such condition, whether anywhere the
Yes.
IO has reflected?
Now, the statement of person who has recovered, your lordship will find at page number 24.
24. Yes. Yes, 29. 29, he said 29.
24, your lordship. Oh, yes, 29.
Because incident took place on 29. He was recovered on 30. Now he's saying 29 morning. Can confirm from the FIR, copy of FIR, when the incident took place, when he was missing.
Your lordship, if your lordship, the incident took place on 28,
Yes,
because
good.
25, the page number 25, he does not say the date of the incident. However, it's written that he was hit on the day and he was found injured on the next morning. So if he was found on 29th,
Yeah.
the incident has happened on 28.
No, on the same day, he said that I was beaten by 3 persons.
Yes.
But then police took a long time to record his statement.
Yes, because as already submitted, your lordship, he was directly taken to the hospital. Thereafter, he was condition was so severe that his statement could not be taken. It was taken only on 14th of February.
Yes. So what do you want to show now?
Now, during the pendency of this case, your lordship, its
Agreement.
agreement happened, your lordship.
Yes.
Now, your lordship is well aware that under 304, even for quashing also, the apex court is very clear, your lordship. The court cannot be nipped in but with especially when even Lakshmi Narayan in the subsequent judgment, Daksaben says ki 307 does not. Now, can a
That's not
agreement
applicable.
be a part of bail?
Hmm.
Because bail is very clear on what ground bail should be given here. Now, subsequent CD, Your Lordship, updated of the CD, Your Lordship. There is another bunch of. Now, Your Lordship is also to be seen if the agreement that they have brought before this court, Your Lordship, was independently without any coercion was signed by the victim or not. If I may take Your Lordship to the statement of the victim, Your Lordship. If I may take Your Lordship to the last page, which is the MLC, Your Lordship. Your Lordship will see last page, Your Lordship. The last page is the medical record.
Form of medical examination.
Yes, Your Lordship will see at column number 2, date of examination was 29/1/2024.
Yes.
And Your Lordship will see 6 is likely to be serious, grievous patients was in subconscious state and grievous hurt, Your Lordship. You are still in subconscious state, Your Lordship. And he was referred to Tinsukia Hospital for better treatment.
This was prepared on
29th. He was admitted on 29/1/2024, Your Lordship.
likely to be preserved.
Yes. Now, if I may take to the second last page of the CD, Your Lordship, which is the statement re-examination of the victim.
Where do we find?
Second last page, Your Lordship. Yes.
Yes, this is re-examination.
Yes. He has
So,
reiterated his.
CD revealed that when it was recorded, and the government in the accused, when it was recorded,
Which one, sir?
this.
This was
statement,
it's
31st.
No, it's written in the above the statements. 31st of March. This is a re-examination. First examination was done on 14th of February. After the settlement agreement was brought before the court, before the IO, Your Lordship,
March.
he was re-examined.
On the exam. Yes. Let us read.
Now, Your Lordship will see he was never a part of the meeting whatsoever was conducted. He was only brought with the paper. Now, subsequently, Your Lordship will see at the third last page, Your Lord.
Okay. So group of people came and asked him to sign on the paper.
The other witness, Your Lordship, will find a page ahead of that, Your Lordship, the statement.
So he do not know what exactly it was.
Yes, Your Lordship will also see a page
second
prior
that-
to that. He is a
Which
witness.
paper you want me to see?
He is also a witness.
Hmm?
Your Lordship will read Raju Thakuria's.
Raju, okay. Who is he?
He is a witness in the settlement, Your Lordship.
Okay. Hmm. notice also signed without knowing
Now,
what is the content
now,
of the
yes.
agreement.
Now, the father of the victim, your lordship will find, I have flagged mark his name is Jivan Thakuria. Jivan Thakuria. He is the father of
His father.
the victim, your lordship.
Okay. Father also said the same thing.
Your lordship will clearly see. He is also very clear, your lordship, that he was not part of any meeting, your lordship. He was just given the money.
Same thing here.
Yes.
So they say.
Given the money for treatment and he was asked to sign a paper. Now, if your lordship will come to the agreement.
Yes.
Now, if your lordship will come to the agreement, your lordship.
Yes. Relevant portion.
Relevant portion,
It says that it must be that the complaint, they will cooperate, withdraw, etc.
yes, the withdraw, it's settled, your lordship.
For
First
their
of all,
advantage.
First of all, under 307, even this agreement does not stand, your lordship, for
Yes,
even
it
for
can't,
quashing.
can't.
Now, my submission before this honorable court is that, seeing the seriousness of an offense, your lordship, this accused person, while bringing into the court's notice about this agreement also, they have been inducing pressure. They have been absconding. Your lordship will see under, this is a 10 years imprisonment. 41A notice is not even required. But circulation was made of a wanted accused. Thereafter, they have filed the bail, your lordship. Now, because they were not cooperating, they had never come before the investigation officer. Their photos were circulated with the prize money, your lordship. Even then, they did not come. 41A, having no option, 41A notice was also sent to their residence, your lordship. They did not come. They came to this honorable court with the bail application, your lordship. On two previous occasions, bail was not granted. Subsequently, why this additional affidavit they brought into the record, the settlement.
Have come before this high court or earlier appeared?
No.
applied
Before this court, on the two occasions when interim was prayed, your lordship, it was not granted.
Okay.
Subsequently, on the next date, they came with this additional affidavit saying that they are engaged with the duty. And your lordship will also see the statement of the accused. He has not been in the duty since January.
Okay.
He has not even taken permission for, while during the pendency of his absconding, your lordship. He was not even attending the duties. Now, your lordship will see prima facie, there is a case, your lordship. Secondly, they have been influencing the witnesses. Also, the putting a peer pressure upon the victim. And thus, their submission is that they were not involved. The other person was involved. The other accused was involved. Your lordship will see that if they were not involved, why would be there any agreement? Now, so therefore, and they have even after granting of the interim, your lordship, they have gone to the IO, your lordship. They have not been cooperating. Your lordship will see the statement.
When the interim was granted?
It was granted on 26/3/24.
Okay, so this was 14 March. This agreement.
Yes. During the pendency of this bail application, they have made they
have filed this.
Your lordship will see on 7th, this matter came up, your lordship.
Okay.
On 14th, they took time.
Okay.
and 14 when the agreement was signed.
Okay, okay.
18, the matter was listed, 21 matter was listed, 28, they had got the interim bail, Your Lordship.
Okay. So,
And they have not been cooperating, Your Lordship. Your Lordship will see that their submission is that they were not involved. However, they signed the agreement, Your Lordship. Their statements were taken, Your Lordship. They have not been able to answer to the questions put up by the IO.
okay.
And Your Lordship will see that
So, whether the accused has also signed this agreement or
Yes.
they have on their
All-
behalf only parents,
all of them are signed.
all the accused persons
Yes.
have also signed.
Yes. Your Lordship will see at page number 8.
In the agreement.
Yes.
Okay, the 1, 2, 3 are the accused.
1 is still absconding. 2 is at item number 19.
But one has
3
also signed.
Yes.
Hmm.
2 is at item number 19 and 3 is at item number 18, Your Lordship.
Okay.
Now they are putting the entire blame on accused number 1 in the agreement, Your Lordship. He is
So-
still absconding.
So the responsibilities for withdrawal of the cases is on the informant. As per the agreement.
Now, my prayer, Your Lordship, is that even during pendency of this petition, Your Lordship, they, even without getting an interim, they have influenced the other party and even brought before the court the settlement whatsoever, Your Lordship, and taking into consideration the statement of the witnesses and the signatories, Your Lordship, is contradictory. There was never a settlement.
This amounts to admission.
Yeah, this amounts to admission, Your Lordship. Also, the fact remains that, Your Lordship, this agreement clearly shows the influence being made to the witnesses. They have been tampering with the evidence. They have been influencing the witnesses, Your Lordship. There cannot be any other ground to cancel their bail application. Your Lordship will also see that they have also approached before the court below, Your Lordship, which is at page number there at page number 17, Your Lordship. 5/3/2024,
17 of?
page number 17 of the main petition, bail petition.
Yes, what is this?
This is the rejection order, Your Lordship.
Okay, they appear. Okay, applies for bail.
Now, Your Lordship will see the incident happened, Your Lordship, on January. They were absconding for nearly 3 months, Your Lordship. They filed their bail application before the trial court on 5th of March. Subsequently, when this was rejected, they have approached this honorable court on 7th of March, Your Lordship. They have been absconding, they have not been cooperating, Your Lordship, and subsequently inducing the influence upon the witnesses as well as on the victim, Your Lordship.
Yes. Yes. So I have to reply on the certain point. So far, my lord, the submission on the side of the government, BP is concerned. This should have been in the case of the trial case. I admit that we have submitted the additional document. This document does not mean that this will be the document to be relayed and this document shall be the used for the trial and this by this document we are not going to quash this present case. only the single issue before the lordship is whether the interim order passed by this honorable court should continue or not.
Yeah.
Why I am submitting, our submitting on behalf of the accused is that this should be continued. This should be regularized on the ground that the agreement between the parties, the agreement is very clear, wherein the person who involved in the involved in the accident has admitted, clearly he admitted that the incident was took place, that the attack was done by him. This is prima facie indicate that the other two accused, which is before this honorable court, before the lordship, has not involved. At the same time, he also admitted and he paid the sum of I think 5 lakhs for the compensation that done by himself. This is the prima facie for the bail stage, which appeared that these two other accused was not involved in this
Why they
case.
have signed?
My lord.
Why they have also signed in the agreement?
My lord, that is the other part.
They are otherwise, according to you, is
Now,
stranger to the case.
my lord,
Why they have signed?
exactly, my lord. We are, my lord, bound because our name has been, my lord, listed as wanted. So far the wanted is concerned. So far the absconding theory is concerned. We have no knowledge. But when we come to knowledge that our interrogation is required under 307, therefore we appear before the session court. But the session court has rejected on the ground that we are not cooperating. And this is the same line submission from the PP side also, we are not cooperating.
If you are
My lord,
interested, you should have cooperated.
Yeah, my lord, in such situation, when 307 case under, my lord, non-bailable case has been registered, my lord, the question of cooperation, my lord, does not arise. Therefore, my lord, we are appearing before the court.
Kindly repeat that one.
My lord,
When 307 is been registered against a person, question of cooperation doesn't arise.
my lord, does mean that we are quite apprehended that we can be
That's why you
arrested.
have it here.
We can be arrested.
Okay.
Meaning thereby the police has no authority to release when arrested. That is why, my lord, we are before in the form of under 438, my lord,
No,
in the
that is why.
anticipatory bail.
This probably the non-cooperation is after obtaining interim anticipatory bail.
No, my lord.
No.
That is not.
Okay.
Only
No,
the question should have arisen
status
exactly if we are failed to
The
cooperate.
status report is of which state? This is of, I think,
The question of the cooperation and the non-cooperation at this stage should be after the granting of interim bail to
yeah,
us.
that is why. The
That
report,
we have been cooperating after
no, this is only, I think, after the interim anticipatory bail was granted to the accused person. That is, when it was granted?
it was granted on 21st March 2024.
21st March.
Yes. Thereafter,
This report is of, I think, prior to that,
yes.
Yes,
status report.
yes, some of these status report that because the CD continues, your lordship, date by date, your lordship.
And bail
What
bond
is
has
the latest
Statement-
report? What is the
bail
latest
bond has
report?
executed.
Just a minute. What is the latest report? Where do we find?
Your
Because
lordship.
thereafter only, I think the record was
Your lordship,
called for.
if your lordship will, after the interim bail was granted, your lordship,
Yes.
it appeared before the IO, your lordship.
Hmm.
The IO's contention is, your lordship will find, I have also flag mark, the pink flag mark in the subsequent CD, your lordship. That is the first CD, your lordship. The second CD,
No, just let us clear. So what his allegation is, what he is submitting is that earlier it was, of course, cooperation was not possible as because they are alleged of having committed 307.
yes.
So now after obtaining interim anticipatory bail, he has been cooperating.
Now,
Now, what is your reply to that?
now your lordship will see that what does a cooperation means?
Hmm.
That you reveal everything, whatever you know, your lordship.
No. So
Only a bare
no,
statement.
just a minute. And then this report, your report is dated 12/3. That is prior to granting of the interim anticipatory bail.
Yes, Your Lordship.
So here, the IO reports that applicant in the particular, particulars are not cooperating. This is prior to the granting of interim anticipatory.
No, Your Lordship.
Now, what I wanted to know, curious about, is what after granting of the interim anticipatory bail, whether they are cooperating now or not.
Not, Your Lordship. Your Lordship will see they have come for their statement. The next page is of 22 March. We have sent the interim bail order of the to the IO.
Next page of,
The second,
not this one.
not this one. The second page is 22nd of March. 22nd of March, Your Lordship will see. The
Yes.
second page, Your Lordship.
Yes.
We have sent the interim bail order, Your Lordship. Subsequent page, Your Lordship, the next page, they came before the IO for 23rd, Your Lordship. 23rd, Your Lordship. On 24th, Your Lordship, their statement were taken. Your Lordship will see their statement was taken, Your Lordship. Lordship will see the IO has also marked that he was not giving a proper answer, Your Lordship, to the queries. Subsequent to their statement, the re-examination of the victim and the other witnesses were taken. Subsequent to their statement, Your Lordship, the statement of re-examination was done to the complainant and the victim. And
25th.
Yes, 25th. Now, the subsequent page is 24th, Your Lordship will see the statement. I have also annexed the statement, Your Lordship, of the accusers. Now, Your Lordship will see he has completely denied being even on the spot, Your Lordship. In his statement, both the accused.
The statement of
The next page, Your Lordship, the statement starts after the series.
Hento.
Hento, Your Lordship. He completely denies even being. Now, Your Lordship.
But
if,
that you can't force.
No. I'm not forcing, Your Lordship. What I'm trying to apprise this
But
court
the only
is.
thing is that whether.
No, Your Lordship will see.
Statement.
If Your Lordship recalls the statement of the victim, he has very specifically, even in his re-examination, stated that there were 3 persons. Now.
And who is the one who has admitted? Which one? This Hento or
There is
someone
no one admitting
No,
before us.
One
Hento.
Nunu
The person who is absconding.
who is abscond.
Is that is not even in our record.
Now then, I think the police would record him. Okay, that may of course be not the reason for rejection, but then
No.
he has not yet been
No.
arrested. Okay.
Therefore,
he
Your
has not
Lordship.
even applied for the anticipatory bail also.
No, Your Lordship.
Okay.
And therefore, even they were not cooperating. Your Lordship will see the interrogation started from January. This is April, Your Lordship. Only after granting an interim bail, they approached before the IO, Your Lordship, where they have completely denied that they were even in the sport, Your Lordship.
But then this the third person has also signed.
Yes,
Put his
3 of
signature
them.
Put his signature in agreement.
No,
The
if-
one who has admitted.
Yes.
Yes, he
Okay,
admitted
he's
he-
there.
Yes,
He's
But
there.
not here.
Yes.
No, not before the.
Okay, I think there's something
Yes.
is there.
Exactly, my lord. He admitted. He himself admitted, and
How do we know that he has admitted?
because his statement is very clear that I was there, but this boat
No, where he has given
accused
statement?
number 2 and 3 was not
Where
with
he has
him.
given statement?
Let us go through this.
Before the police?
No, by the police has not so far.
Yeah, that
since
is right.
is
Where he has
absconding.
given statement?
As per the agreement, on the basis of the
yes.
agreement, he
Yes,
admitted
yeah,
that,
that is right.
whereas on the incident of the, whereas on the day of the incident, the first party number 2 and 3, this is before the honorable court, have not involved in the alleged crime.
Okay.
However, the first party number 1 has admitted that there was a clash between them due to the argument over the using pool of the
Okay,
victim.
that is the one who is absconding is giving
Yes.
certificate to the person.
Yes.
Hmm.
He
Now,
admitted that.
now your lordship will also see this agreement, as I
Yeah.
already pointed out, your lordship. It was the victim's parents, victim was also not present. This is just an agreement that was allowed to be signed, your lordship. Now, who came to the part, who came?
Now,
to the-
now let us deal with the things. Now, since they have already been arrested, bail bond executed.
Yes, your lordship.
Now, how do we do?
Your
What
lordship,
is your submission at this stage?
your lordship will see their conduct, your lordship. During the pendency of bail, your lordship, they have been influencing with this agreement to settle the matters, your lordship. Now, your lordship will also see the statement of the victim as well as the other witnesses who purportedly has signed this, your lordship. Now, your lordship will also your lordship will see this agreement was signed on the same date. One of the accused is absconding. 2 of the accused comes to the same place with the accused number 1 and sign. And now they say that we don't know where he is. They are not even cooperating about his whereabouts. And the fact that
I think there's something.
No, the submission of the
So
PB is
so probably they are playing game which they are not expert, in which they are not expert. It appears. Something.
whatsoever,
Like something
my lord, that maybe.
Should have planned better.
But what is appear as per the record, the court is honorable. The court is need to ascertain that we are cooperating whether we are jumping over the bail granted by this court or not.
That's
It
true,
was
that's
not
true.
only for that particular day of the 24th. We are ready to all the time, whenever. But this cannot be the ground that the answer,
That is
the question put to us is not satisfactory. Till the satisfaction of the investigation,
that is true.
that need not to be.
That is true. But then can the court also be remain as a mute spectator when the court knows the game from the face of it played by the accused persons? It's very difficult sometimes. Anyway, so
Therefore, prayer that the interim order pass earlier be regularized. We are ready to cooperate.
probably it will be difficult at this stage, given the fact and circumstances of the case. And then see the statement. This is the original copy of the CD.
yes, no, your lordship. That's since your lordship is this is from Shantipur, your lordship.
Okay.
The CD. Therefore, it was sent through the mail.
Scan copy.
Scan copy, your lordship.
But then you should have asked for the report.
On the first date, your lordship, they have brought the original copy, your lordship. On the second date, your lordship, they were the IO was
No, the report of the latest. So latest
the
the
first.
status report, no?
Yes, your lordship.
That maybe the same thing if
Yes.
they repeat it, the fact and circumstances.
At least their
of the
observation.
cases are same. Yes, and the observation that even after the even after obtaining the interim anticipatory bail, the accused
Yes.
is not cooperating.
Yes, your lordship.
That is
That is
not-
only
not correct before this.
there.
No, if she says because the record shows that they are not cooperating. It appears the record shows 24, 25. So March 3rd. These all records. The CD is there, but then the report is not the latest one.
On the first.
Although the case diary is the latest one, but the report, status report is not the latest one.
Yes.
Basing on the case diary, not based on the case diary.
Yes.
So it will be difficult.
So one thing, Madam, one thing I would like
Yes.
to clarify
Hmm.
that so far this cooperation is concerned,
Hmm.
the interim bail was granted on 21st. Thereafter, we have
It was with the assumption, on the assumption that they would cooperate.
it was
with the
granted
presumption,
on
with the presumption.
yes,
Hmm.
and accordingly we appear before the IO on 23rd.
Hmm.
Thereafter, statement is taken on 24th. This is though the CD is not with me, but this is as per the record of the PP.
But you see, there is a subsequent development.
No,
Subsequent development is that although the entire, you see, the statement of the accused, but they says that the other one is, he have never appeared, not even applied for the anticipated bail also. He took all the responsibilities that he has committed and to save these two people, two persons. And on the same day, when the anticipatory bail was granted to them, they have executed the agreement.
no,
Where?
ma'am. Agreement was before
14.
the interim bail was.
It was
done.
14.
Yes, ma'am. It was on 14.
During the pendency of the bail.
Oh, sorry,
petition.
during pendency of.
Yes.
Okay.
That the agreement was before the prior to the
And interestingly,
interim order passed by this honorable.
Hmm.
And after passing of the interim order, we have been cooperating.
At the time of obtaining interim order, this agreement was already there.
Yes,
Yes.
on the basis of this agreement, on the
Okay.
basis of the agreement and the additional document.
I have no idea,
No,
but
no,
I
Your
have
Lordship.
noticed
Yes,
that the absconder is also here. I have noticed. So that's a trouble.
yes, that is there.
That is a
That is
trouble.
there. I also admitted that the absconder was also there. That agreement was executed on 14
Hmm.
March. Thereafter, on the basis of this, while placing this agreement before this honorable court,
Hmm.
on the basis of this agreement and other document, the interim order was granted on 21st March. Thereafter, we have been continuously cooperating, and we are all the time we are ready to cooperate. Now, the purpose of interrogation is to, my lord, interrogation required
Where the document, where
that
they have
since we are ready to
appeared,
appear.
signed, executed bail bond, etc.
Yes.
Where do you have the record?
the bail bond, it's not written, but Your Lordship will see the CD, it's in the CD, Your Lordship.
Therefore, at this pre-trial stage, the statement is already recorded, and
Mhm.
The
if
fourth,
any further
the fourth-
statement is required, we are ready all the time.
the fourth page, Your Lordship, on 29th, third, they have come with the recording of the statement, Your Lordship.
Hmm?
On fourth page of the CD, Your Lordship. It's there in the CD. Your Lordship.
What is that?
The subsequent CD, Your Lordship will find.
This is not the.
That is the first CD, Your Lordship. Yeah.
Subsequent CD.
Yes, the one, yes.
Hmm.
Your Lordship will see in the fourth page, the,
Yes.
yes, 161, Your Lordship.
Hmm? This fourth. is
Fourth.
not-
Down below, Your Lordship will see. Now accused Sunny Ratan so and so release on interim bail order from Guwahati so and so each so and so. The next.
March.
Your Lordship, the petitioners were asked to appear on 24th of March
Hmm.
for giving
Bail-
their
when
statement.
the bail was executed.
It was executed on 24th, Your Lordship.
24.
Yes. Though the same has not been written, Your Lordship.
Not written.
Yes.
So how do we know that it was?
Because they were not arrested, Your Lordship. After they were not arrested, Your Lordship.
Not
Yes.
arrested.
Yes.
Yeah, where have you executed the bail bond? If not arrested?
My lord, that is the unfortunate. Without my lord arrested, how the bail bond will be executed?
Do you have the receipt?
My lord.
Because
Execution of bail bond means, my lord, they have been arrested.
My submission was
I
that
think it appears that if the bail bond has been executed, that he was
Executed, yes.
arrested only.
yes, Deputy Overjudge, my submission with regard to arrest was that like after execution and their statement, they were released, meaning thereby the bail bond was executed.
Mhm.
My submission.
Mr. Mori, it will be a little difficult for me under the given fact and circumstances of the case.
My lord.
Hmm.
My lord,
So,
what?
you have anything, Samisa?
My lord, despite of my lord, that's notice remain, but what is the case before it?
There is a play which doesn't convince the court.
No, that is not. In fact, my lord, this is the PP from the side, my lord. This bail argument should not be, my lord, up to this extent, my lord, since this is not the trial court. This is the bail court,
That is
therefore.
investigation says, that is why I'm not inclined to interfere with the investigation. Now that will amount to interference of the investigation, because the investigation is ongoing.
My lord.
And then they are playing with. How do we interfere under the circumstances? Very difficult.
My lord, that part whether, my lord, that is playing or not, my lord.
So-
I'm not on that part.
Had it been the case, in supposing if all the accused person have given statement, then case would have been much different, altogether different.
Exactly, my
I
lord.
will go with you only.
Though, my lord,
I would have gone along with
though, my lord, the CD is not with me, but this is that submission from the PP,
The CV
that the
CD
statement was recorded on 24.
It is there.
Your Lordship will see the
Thereafter,
previous order, Your Lordship.
Even that.
When was
also-
he asked to appear
that-
before the IO? That I may be made clear of that. Your Lordship.
Even after 24 also, whenever, my lord, I will be called for, we are ready all the time, man. So question is that whether we have jump over the bail or not. We are cooperating, man. Yes, interim. So, in the, my lord, the cardinal principle of criminal law, my
Yes,
lord, to make bail, to grant bail, my lord, mean to make ensure that the person will cooperate the, my lord, investigation. That part, my lord, we are trying.
Now,
We are
see,
in trying to
now
cooperate.
also they are hiding certain things which attracts some other section again.
My-
Now also, if
my
they are
lord,
hiding,
for
because
that,
thereafter only, they met the co-accused, and yet thereafter, they have given statement before the police that we do not know whereabouts of this person. After that, after executing the agreement where they met, all of them have signed. Thereafter, they have given false statement before the police saying we do not know whereabouts of the person.
for that, my lord, what I can say only that we can assure that at any time, whenever the IO will call for, we'll be ready there. So
It's
it's
a little difficult to convince. Okay. Okay. So I think there are other matters also we would like to complete, and I'll pass an order
Yes.
on this. Okay.
Also, Your Lordship,
Alright.
if I may pray, Your Lordship, the unmentioned,
Hmm?
the unlisted item that was
Okay. This I'll pass order.
Yes.
Huh? So we'll keep it for
Yes.
time being. So it will be released. All
Lordship, if I may, Your Lordship.
record na heard Mr. Modi, counsel for the petitioner. I've also heard Ms. Jenny, PP. Okay. We'll pass
Lordship.
it on, huh? So, Chamber.
Your Lordship, my humble prayer, Your Lordship.
So what is unlisted matter?
There was an mention of an unlisted matter which is already before
What
Your
is
Lordship.
that?
My difficulty is, Your Lordship, I'm not feeling well, Your Lordship. I'm one of the party respondent in this matter,
So
Your
you are
Lordship.
here.
I had-
So this
I-
is for?
No, in this case, on 27th of March, this honorable court had passed an order to issue notice to the respondents through AD card.
Okay.
However, there are 22 respondents and we're running short of stamps, like postal stamps.
Okay.
So
you
we may
want
be allowed to
further
take
time.
dusty service.
If I
We may
may,
be allowed to take dusty service on the
Okay.
respondent because the
Okay.
matter is fixed on 8th
Third
of
minute.
yeah, no, Your Lordship, if I may, Your Lordship. If I am absolute right with the Guwahati High Court rule, Your Lordship, This matter came on 27th, Your Lordship. Subsequently, this matter was fixed on 8th.
Hmm.
Now, prior to that date, if there was no given date, that would have been a different case, Your Lordship. When the matter is given a fixed date, Your Lordship, can a matter be mentioned prior to that date, Your Lordship?
Release the matter on 8/4. 8/4 yet to come.
Yes.
Your Honor. Because there, we are running out of postal stamps and the matter is fixed on 8 for final disposal.
Prayer
final
was never
consideration.
Final disposal.
No, no,
final
not final
consideration.
disposal, only for consideration of
It is
interim.
for final
It will come before this
consideration.
court only.
Yes.
Your Honor.
We'll pass order on that day.
Yes.
But
Give
then
it
it's
some-
an
some
election
more
matter,
time.
Your Honor. There are certain
Because-
emergencies with
Because
regard
this
to
is,
it.
you see, date is already fixed on 8/4. Let it come on 8/4.
Yes, Your Honor.
Let it come on 8/4. We'll pass the same order what you are praying now, the same prayer you made. We'll-
But Your Honor,
we'll
because
keep time.
of the emergency with regard to the elections, this matter was specifically fixed on 8th. So that because of exigencies in time.
No, Your Lordship.
And if on that same
No.
day, if the notices are not issued on before
Now,
that date,
now
then
in that case, we'll have to modify this order.
Yes.
It will be
Yes.
trouble. It will be trouble.
Also,
Then you have to file before this court. The same.
because Your Honor, without the order of this honorable court, we cannot take steps other than the AD card mentioned in the order. So that is why it was mentioned so that this honorable court can grant us that.
I
order.
think it's a
No.
question of service only.
Only
no,
on
but then
service.
my issue with regard to this is that, Your Lordship, the rule clearly says that before, now even the bench,
That will be,
who can modify this is also,
no, that will be difficult.
Yes.
Modification we can't.
yes,
It has to be by the same judge.
yes. If there was
It
no,
amounts to review.
yes,
It will be difficult.
if
But then,
on 8, she
is it the urgent?
Yes, Your Honor. It's with regard to People's Party of Arunachal matter, which we are challenging their election. And the nominations are already being filed. So we need to be able to dispose
But
the matter
that's
as soon as
difficulty
possible.
that order can't be changed. Cannot be. At least by me, by the other judge. This amounts to the review of the same order, said order. It will be difficult. Let us wait,
And make a mention.
make an effort so that
Then-
the
then,
notice
Your Honor, this-
reaches them.
This case may be listed tomorrow before the.
Yes,
principal
you
bench.
can mention, you can
And I
mention. You mention there.
I had
be
mentioned it in
better.
the morning before court number 1. Where I was directed, because it's a CRP, I was directed to mention it before this court.
Mm, Inform that, because it has to be before the court. who
Even,
pass and-
passed the
even,
order.
even,
And then inform this, that the order was passed by His Lordship,
Yes.
and it has to be modified by His Lordship only.
yes,
That can be done,
Okay.
even in the principal seat also that is done,
Okay.
if it is urgent case.
even,
that.
even Your Lordship, they can file an IA for modification also, which
Right.
will be, there will be
It has-
another order saying that so-and-so has been modified. Your Lordship.
Yes,
That can also be
Okay.
done.
do that, okay,
Deeply.
Okay.
yes. Next item. This is in that case. Hmm? No. No.
May I please close it? Here, I was granted interim on 21/3/24. I appeared before I on 26/3/24.
Just a minute. Order, order,
On dated 21/3/24, I was granted interim by this honorable court.
okay,
On 26, I appeared before IO. This it's a small matter, only 354. Then,
three
yes,
fifty-four,
yes, of IPC. I've already given my statement twice before IO.
so you have been arrested,
Yeah, I was protected. I was arrested.
protected,
Yeah.
but then you appeared
Yes,
before the
I
police.
appeared on
Whether the
26.
police has arrested you?
Yes, Yes, on 26,
The
yes.
interim anticipated bail bond executed,
yes.
you have any document?
No,
CD is there?
it should be there. and see.
For information, just. Yes. So, what was the allegation?
Lordship,
You
allegation
have
is,
not annexed FIR.
FIR is there, Lordship.
Yeah,
Yes.
content of the
Page
FIR?
14.
page 14.
Lordship, I have uploaded some
Okay.
scenes of the
Okay,
victim, that's why.
so in abbreviated condition.
Yes.
So subsequently it was deleted. No.
Yes, it was
Couldn't be,
deleted.
but then in the meantime, people have already seen.
Yes.
So this is against you.
Yes.
Now,
According to allegation, only section 67 of ITX should be affected, and that is bailable. Otherwise, this is fit case to be charged with it, and already 3 months have been passed for investigation.
already
3 months have passed.
passed.
Yes, I have already appeared twice before IO.
But you are protected only.
Yes, sir. Interim may be met absolutely.
So, Lara PP, what is your submission? Is there any material which you
Yes,
think that cannot be?
Report is still awaited. The site report, telegram, that's called social site.
Will then post it? Protection, you are already under protection. Protection, okay. Mm. So we'll see that if there is a serious, we'll see that if the report comes out to be a positive or something else.
Yes.
Okay, we'll see that.
Okay.
Okay. Mr. Bodilana counsel for the petitioner. I've also heard Mr. Tado, G. Tado, PP. Although Mr. G. Tado, Dana PP has produced a scanned copy of the CD. He has submitted that. What is this?
That is the report, telegram report.
Report?
Telegram report. That is telegram is a name of social site.
Okay.
Then it was as per FSL mobile, the seized mobile of the accused. It disclosed that it was used by the accused.
Okay.
And the material was deleted, photo.
Okay.
So in report telegram headquarters, it was sent for a report to trace out the deleted deleted photos.
After sieging.
Yes.
Sent. Okay. So the telegram report is still awaited and praise for some more time. So the prayer is allowed. So please break. List this matter after. Yes. Number 21.
Please, Varun.
Yes.
Here in this case also, my lord, I'm under interim protection by the order of this honorable court that was passed on 27/3/2024.
Yes. So,
Kindly, my lord,
Yes, my
look into the FIR also.
We have. The allegation?
Allegation is simply saying that of course, we also deeply saddened by the incident.
306.
306. So there is no any specific allegation against me. Other than that, I was in extramarital affairs with the husband of the deceased.
So at the time of incident, whether the accused was present in and around the place of the incident? No.
But however, since they were into relationship.
Sometimes it is very difficult to prove the inducement.
At this stage, my lord, it's very difficult to justify that. But since this matter is in the very nascent stage, proper investigation is required, madam.
Okay.
Since she has been in relationship with the main accused person since last 9 years. And there was various scuffles between the present alleged accused person as well as the deceased person and the other mistress as well. So that is the reason, my lord, on the last occasion, my lord, the interim was granted only on the ground that she had to appear for B.Ed examination, only on that ground.
Okay.
Otherwise,
What about the main accused?
main accused is under custody. my lord.
Under custody.
Now, if you see the contents of the FIR, my lord, she is a named FIR in the case, my lord. Therefore, my lord, at this stage, my lord, to my understanding, my lord, undoubtedly, menstruation is very important to attract section
Right,
306, my lord. But at this stage,
Ah.
since it's been only one way, a free hand should be given to the investigating authority to gather the evidence, my lord. So that is the only reason, my lord, we have an objection.
Whether her statement, not.
No.
After granting interim, my lord, she has not appeared.
Not after granting.
My lord,
interim,
my
did
lord.
not appear.
My lord,
No.
may I?
Maybe direction.
Let me,
Yes,
let,
please.
let me continue, my
Please,
lord.
please.
The state machineries, my lord, is being misused in such a manner, my lord. Kindly,
Specific direction, I think. Shall I appear
specific
before
direction. On
29?
29, I have to appear. What happened, my lord? This is the letter that was written on 28 to the SP. And kindly subsequently, what happened on 29? That we have appraised again to SP. And this is the situation that is frustrating even the order passed by this honorable court, my lord.
This is written by the alleged accused.
Yes, applicant.
To the SP.
SP, my lord. Now what happened? 29. It is updated. Another. Subsequent. In the subsequent one, I have narrated everything what had happened in 29, on 29. They have done nothing. 29. I tried to enter, but then due to the protest, that is written in the letter, my lord. Whole day, my lord. She was not allowed to enter inside the police station. We'll bring it on record. Yes, my lord.
So I think she is facing some trouble. She has not been allowed to enter. Her house also disturbed. Rather, she is asking for the police protection. Try to call the police also.
We are not
Can-
we are not
have you
aware
seen
of
this?
this
Have you
document.
seen this?
No, my lord. We
Please.
have not been served with a copy of it.
So under the circumstances, probably the police may not be able to say that she is not cooperating.
But so
Under
far,
the
my,
circumstances.
so
Just
far,
can you see it once?
We understand the emotions, my lord. But then if my cooperation is not there, how police will investigate?
If she has done so much of effort, I think she deserves to be given some more time. And then, what is this?
in that way, my lord, that the council may bring this stand on record.
Let him,
Bring the stand
you
on.
just let it, bring it on record, file by additional affidavit and thereafter also. And then in the meantime, try to make an effort and this will continue,
My lord.
interim will continue. And then, so this way,
Otherwise, my lord, the interim was granted only for the purpose of appearing for a B.Ed examination,
right.
which was supposed to be held on 28th,
Right.
2 days back.
yes.
Now the examination is over.
Now, but then other circumstances,
Yes, my lord.
if her statement is recorded by the police,
Yes.
and then the police,
Not only that,
Follow
my
the
lord. If
procedure.
there is single material, we'll surrender, my lord. Nothing is there,
Then-
my
then
lord,
it's
except
okay,
that
good to
she
know.
was in relationship
Her
with this
involvement.
accused.
Let them bring their stand on record.
okay. So, is there any, just a minute, is there any incriminating material?
As
found
of now, my lord, only the statement of complainant as well as one of the accused has been recorded.
accused?
Otherwise, my lord, there's no
Whether
other,
the accused has revealed something that her involvement?
has disclosed the relationship, my lord. But since unless and until her statement is being recorded, my lord, the proximity between her and the deceased
Comparison.
would not be able to bring on record.
So, what we can do is giving her some more time. And in the meantime, she also make an effort, the IOC also, because she said that according to her, she said that she tried to contact with the IO.
Yes,
OC also was out of station probably when she appeared. And now the IO should also make an endeavor to facilitate her appearance to record her statement. And then since she is trying to contact, and then the IO can also go to her to record her statement. And then if possible, safely, if want, can take and then execute if possible, if wants. No? So that facilitation can instruct the police also. And in the meantime,
Otherwise, my
let
lord, we are
her
not
be-
sure about the authenticity of this document as well. Even
Then
without
we
going
do.
into the merit of the case, my
that it will come out after recording her statement by the IO. I will now, because it will be like interrogation only. I was present. Now, how could you say this? No? So, we'll interrogate. Yes.
I'm here.
You are for?
Complainant. Okay. Lordship, in this case, last time I think Lordship, the applicant, they have previously the report that they are wife of this, the alleged arrest of the accused person. Lordship, so far, no such husband and wife has been socially declared.
She has not yet stated anything,
Lordship,
probably.
as far as this bail application.
Bail application.
She was considered to be as a wife,
No, Lordship,
and she was living with.
actually, this is the fact of the report is from the whole So,
Not legally married.
yes. No.
They says not legally married, but then
Then it will be difficult.
they says
Maybe living relation, whatever. but
living
then-
relation. They says extra.
Unless you are married, so because this side, the wife is now claiming, of course, no more, but then the family is still there. They're still there claiming for the wife, deceased wife. So under the circumstances, it will be difficult for you also to introduce yourself as a wife unless you are married.
Because my lord, what happened? 10 years of living in relationship. It's
But not a wife.
not. But then this accused he introduced somewhere before a relative also.
On the basis of that.
Basis of that I have.
Because of that 10 years,
So now he
this relations lead to the causes of death of that my younger sister.
Okay.
So entire mastermind.
May I bring it on record?
Yes, yes, you bring it on record now. Mr. Tama, Nine Council 4. the petitioner also heard Mr.
J3. J3.
Okay, Shirin, Rana PP. I've also heard Mr. Tappu, Lion Council appearing on behalf of the victim staff. Mr. Rama prays for some time to bring on record some documents which
What it's showing, subsequent development. Possible maybe on 5th, but no 5th, I'll be not. On 8th, my 8th or 9th. 9, it's okay, 9. Maybe allowed to return the case there and bring the pressure on. You return? Meantime, my lord, interim may be continued. Highly obliged.
till the next game. It is up till the next game. Okay. Yes. I think
Your Lordship,
the court time is up to 4:15. 4:15.
Your Lordship,
Yes.
I'm for the conducting counsel, G Talo for the petitioner.
Okay, you are for?
G Talo for the petitioner.
Okay,
Your Lordship, I would like to withdraw this petition.
okay. Mr. Your good name?
V Gurung.
B.
Gurung.
Your name is also here?
No, Your Lordship.
Appearing on behalf of Mr.
G
Jita
Talo,
and counsel for the petitioner wants to withdraw
this application.
this. Civil revision petition.
Also, Your Lordship, like one more item was there, item number
Okay,
34.
That now, okay, okay. This civil revision petition stands dismissed on being withdrawn. Okay, let's dispose of. Just a minute. One more, which one?
34, Your Lordship. It
24.
was 34. It was adjourned for 2 weeks, after
Okay.
2 weeks.
Yeah.
But however, we are informed that it will be fixed for 1 week later. And it was fixed for 2 weeks by the opposite counsel.
When do you want?
Maybe this coming 3rd or 4th.
Third or fourth?
Yes, sir.
Since it was, no, in the morning, it was informed that there was a consent from you.
Yes, Your Lordship, but it was only for this 3rd or 4th. But however, they did not inform us that they would be
I have no idea,
taking.
but then they submit that on the information of the, on the consent of the other side, they said, probably. Is there any urgency?
Yes, Your Lordship. It has been pending for 1 year, Your Lordship. And they've been seeking adjournments.
It was adjourned for 2 weeks.
Yes, Your Lordship.
Let it come.
Okay.
After 2 weeks. Okay. Next,
Obliged, Your Lord.
about. So, my lord, I am appearing for the respondent number 1 and 2. Color number 5. Enter appearance. I may be, okay. Allot 4 week time to file my affidavit. Okay, hard, Mr. Your good name?
Paso Dalbong, my lord. I'm the petitioner. Paso Dalbong.
So now, and counsel for the petitioner, Mr. O Modi, would appear on behalf of respondent number 1 and 2, and prays for how much time? 4 weeks time, 4 weeks time to file affidavit. The prayer is allowed, list is matter after 4 weeks. Okay.
Number 27.
My lord, hearing this case also, I am appearing for all the private respondent. Okay, you are for petitioner.
Petitioner, my lord.
So here, I may be allowed, for extent, to file my affidavit similar. Order, no? Okay.
May your lordship,
In the last page, for all the respondents, huh?
may I,
Yes.
lordship?
Yes.
Lordship, we want to withdraw this matter.
Hmm?
We want to withdraw this matter.
Okay, item 28.
Yes, lordship.
You are Miss
Tana Rini, T Rini?
for petitioner?
Yes,
Miss,
yes, your lordship.
Miss Tana,
Rini.
Land Council for, your name is there?
I'm appearing on behalf of Mr. P. Tapo.
Hearing on behalf of Mr. Peter for Land Council for the petitioner wants to withdraw this criminal petition. No liberty, okay, criminal petition, stop, huh? You have no, any?
I will close it.
No objection, okay. No, Mr. Miss so-and-so and Mr. Tado, VP, huh, stop, Miss, her name, huh? Wants to withdraw this criminal petition. Stop, huh? The prayer is allowed. This criminal petition is dismissed on being withdrawn. Okay, so stand displayed. Okay.
Much.
Yes. Yes.
May I send, my lord?
Yes.
My lord, as per the office note, my lord, it seems, my lord, service to respondent, private respondent,
Not
A
yet
with.
received.
And the
LCR also not received.
My lord, my humble
Service
submission.
support, yes.
LCR maybe again a reminder. Maybe,
Reminder, okay.
LCR, and I will wait for my lord. I'll try to cross check the my lord service to those private respondent. my lord.
Land Council for the petitioner. Also, Mr.
J. Sri.
Land PP, staff, huh?